Main list, item number 1.
I'll see Act.
Yes, please, Lord.
Where you are? Yes, Mr. Mr. Paul is. Oh, Mr. Paul is here. Yes, yes.
Yes, sir. The issue which is calling for lordship consideration is whether the order passed by the tribunal is without jurisdiction or not, and then whether the lordship would exercise the jurisdiction under 226.
You have to take. You can't take both, either 226 or 227.
Yes, 227. My argument is.
Lordships, more importantly, what I'm informed is before my learned friend begins, against the same order, my lord, some appeal has been preferred before the appeal.
Who has preferred the appeal?
MECL, my lords.
Is that correct, Mr.
I have the status report.
You are saying that against this order there is no appeal, my lord. Against this order there is no appeal.
No,
Now,
please.
let my friends know that there is appeal against this order.
Well, what they have done.
We can't start.
That
on
been a piecemeal manner, my lords. They have now probably challenged the earlier order. This development is, my lords, after the matter was heard by your lordships on the last occasion.
There is no appeal. See, as I am instructed to say, there is no appeal.
Who's Aditya Kesing?
Now, Aditya Kesing is a lawyer of
Did he appear before the tribunal
a tribunal.
on behalf of the? He
did appear. He did appear, my lord.
I mean, your volume is quite low, Mr. Attorney General. Can you just increase it a bit? Now, what are these matters then? No numbers are shown here, Mr. Paul.
Well, it's because this matter has just been filed. It has been filed. Date of filing is 3/8/2023. Your lordships will kindly see. And the matter was taken up where? Before this court?
Last week. That was on Friday.
4th March.
Mr. Afghanistan, you kindly confirm. We'll have it after some time.
I'll after some time, my lord.
End of the board, my lord,
I'll take it.
You kindly check in.
Yes, sir.
Come on, submitting this motion.
Supplementary list, item number 1.
Niyat Razarika?
We are challenging the order of Meghalaya Lokayukta, my lord. Passed on 10 May 2023.
What is the order about?
Yes. Order is a page number 50, my lord. Last paragraph I am reading, my lord.
Yes.
Most of the work have been completed as per the preliminary report. However, the following work are yet to start, but the waste amount have been credited to the bank account of the job card holder, my lord. Construction of Jivable Road with retaining wall at Kasharipara. Construction of CC footpath at Kasharipara. Construction of elevated water tank 5 numbers. Hence, I am satisfied that there is no prima facie case of corruption against the public servant as per the preliminary report, and the case is disposed of as follows. Number 1. The Community and Rural Development Department shall cause an inquiry regarding the payment of wages to the job card holders when the work have not been started as mentioned in this preliminary report, and take action accordingly. The proceeding is hereby disposed of. My lord, as per the preliminary report, there exists of the prima facie case against the VSA functionaries and the ex-BDO of Shalshala block, my lord. No work has been done, money has been drawn. In that case, that Meghalaya Lokayukta cannot give a direction to the Community and Rural Development Department to cause an inquiry as per section 20 of the Act, my lord.
What does this say?
Yeah. No, this Meghalaya Lokayukta Act, my lord. They have 3, my lord, 3 plus 3A.
Just read it, just read it.
Yes. Here, my lord, just I'm.
You say that he cannot direct for causing inquiry.
Yes.
Although no prima facie case has been made out against the respondent, he means.
Yes.
He means you're alleging misappropriation, correct?
Yes.
Now, according to preliminary inquiry, as per his order, it says that
Yes.
works have been completed, and regarding the works not been completed, the amounts have been credited to job card holder. That means to the people, the villagers.
Yes, yes.
Right, so you're alleging that there's some
Yes, that
irregularity
not only
in-
that, another also in the preliminary.
Now, let's see 3A, where is that?
Yes, 3A, my lord, investigation by any agency, including any special investigation agency. After filing the inquiry report, after filing the complaint, my lord.
3A?
Yes,
I have to go.
page number 14, my lord. 20, my lord. 20, section 23A, my lord.
Just amend it one. 20.
Section 23A,
One second.
clause 3 with the clause 3A, my lord.
23, right.
Yes, my lord.
Yes.
After filing the inquiry, if they will find something is there, they have to refer the matter for investigation, preliminary investigation. After completing the preliminary investigation, my lord, they can do again investigation by any agency, including any special investigation agency, initiation of the departmental proceeding or any other appropriate action against the concerned public servant by the competent authority. C. Closure of the proceeding against the public servant and take action to proceed against the complainant under section 47, my lord. Here is the question. For giving direction, if something prima facie find by the Meghalaya Lokayukt or tribunal, they have to give the further investigation, my lord.
Okay. Yes, heard. Mr. Where's Mr. Jindal?
He's indisposed, Your Lordship.
He's on the.
No, Your Lordship. I'm appearing, Your Lordship.
Okay. Heard Mr. H. Hazarika, if you notice.
I'm appearance on behalf of Respondent 1 and 2, Your Lordship.
Which is present behalf is present except notice behalf respondent 1. Move for the notice called for. 1 and 2 or just 1?
1 and 2, Your Lordship.
1 and 2. So Bishop takes step for issuing the notice on the remaining
3, 4 and
respondents. This of the 3 weeks for affidavit. Yes.
Much obliged.
Much obliged, Lordship.
Item number 2.
Please, Lordship. Your Lordship, I filed this application under Article 226, 227 of the Constitution for issuance of writ of mandamus or any other appropriate writ, Your Lordship. Lordship, the brief fact of the case is that the respondent number 7 herein had forwarded the letter to the respondent number 2.
Number 7?
Respondent number 7 is the principal of the Paimong school, Your Lordship. She had forwarded a letter to the respondent number 2, white letter number 8, dated 8/6/2015. You can find it at page 19, Your Lordship, of my petition.
Yes.
Further, Your Lordship, in the last portion of the letter, she has also stated that the post of grade 4, which is a post of dormitory, may be filled up by the respondent number 4, which is the district selection committee, Your Lordship.
Yes.
And thereafter, Your Lordship, I have made a application before the said respondent, and I have submitted all the relevant documents to the respondent number 7. And sometimes in the month of October 2015, the respondent number 7 had published the vacancy post in the local newspaper, Your Lordship. The respondent number 4, which is the district selection committee, on completion of the filing of the post, had issued a admit card to the petitioner, Your Lordship, to appear in the written examination, which was held on the 6th May 2017. And Your Lordship, we may kindly find it at page 20, which is annexed to, Your Lordship. And thereafter, Your Lordship, on clearing the written examination, the petitioner was called to appear for the personal interview before the respondent before on the 28th 8/2017, White Letter 8/2017. Your Lordship, that you kindly find at page 21, which is annexure 3, Your Lordship. Your Lordship, thereafter, on completion of all the selection process, the respondent number 4 had a declared result of the candidates. White Letter number 6/10/2017. The petitioner stood at serial number 77, Your Lordship. And thereafter, Your Lordship, the respondent number 4, White Letter number 28/11/2017, had recommended the name of the petitioner. Further, the respondent number 4 had forwarded letter dated 15/12 for recommendation of the petitioner to the post of draft 3, Your Lordship. And thereafter, Your Lordship, on receiving the letter dated 15 December 2017, the respondent number 7 passed an order dated 23/12/2017 appointed.
When did he join?
On the 23rd December 2017, Your Lordship. My joining report is at page 31 and the type copy is at page 32, Your Lordship.
Okay.
And thereafter, Your Lordship, the respondent number 7 passed the order dated 23/12/2017 appointed the petitioner to the post of lab bearer instead of the post of draft 3, Your Lordship, which is contrary to her first letter, which is letter number 8/6/2017.
They're both grade 4 posts.
It's the same post, Your Lordship.
Then what's the difference then?
The difference
Lab
is that
bearer and draft 3.
no, Lordship, the scale pay is different, Your Lordship. The scale pay is different.
Where we said that?
Huh?
You've given the poor scales of pay.
Yes, Your Lordship.
In the pleading.
Even Your Lordship, may kindly find at page 34 also, Your Lordship.
Yes,
And
34. No. Where you've shown the comparative pay scales? To show that there's some difference in the
Yes, Your Lordship.
service conditions.
Can you give me a second, Your Lordship?
Draft 3 is, I mean, even though the grade 4, the pay scale is higher.
Yes, Your Lordship.
Okay.
Your Lordship, para 17, page 13 of my petition.
Para 17.
Page 13 of my petition. I've made a statement there.
You would have said, anyway.
Okay.
So they made you join as lab bearer.
Yes,
instead
Your
of draft 3. So you agree with that?
Yes, Your Lordship.
Okay. Who's appealing for the state?
Your Lordship, I'll accept notice on behalf of the state.
I heard Mr. Khandangbak, the counsel petitioner, issue notice returnable in 3 weeks. MSZE now can be is present accept notice on behalf of the respondents number 1, 2, 3. 1, 2 and 3. I will appear with member secretary district section committee also.
Yes, Your Lordship.
4, 1 to
3 and
4. So, no notice, no further required on behalf of the respondents. Please take step for issue of notice on the main respondent within 3 days. Just after 3 weeks for service report and for affidavit by the state respondents.
Are you black?
Item number 3.
All the respondents. Item number 3 and 4 similar matters, this is with respect to the Directorate of Urban Affairs, Urban Department. There are 2 posts of joint directors. Now these 2 posts became vacant respectively during February 2022, and 1 post became vacant during April 2023. The petitioners in item 3 and 4, they are the senior most, and they possess the requisite qualification of having a master's degree in town planning. Now, despite being eligible twice over the DPC sat, but the petitioners were never considered, and neither they have taken a call on promotion to this.
What do you mean by DPC sat? They sat to consider promotion to joint director post.
In between October 22 and December 22, they sat for some other post.
Oh, then you can't say the DPC for these posts.
But the DPC sat, but never considered. Now, in June again,
no, if it doesn't come for consideration, how will you consider?
We come within the zone of consideration.
No, I'm not talking about your zone of consideration. By right, you can't demand promotion. But what the court is saying is that you see the DPC sat, but did not consider.
Yes.
Was it put up for consideration?
That we do not know. That is why we are before your lordship, for consideration. It's been lying vacant, it's a small department, and these are very
how many years? What is the criteria you say?
Criteria your lordships may kindly have. The OM, my lord. Now, there are no rules, my lord, in the department as yet. No rules have been formulated. There's an OM of, my lord, 2008.
Page?
Page 22 and extra 5.
Page
Clause
22.
2, my lord. Clause 2 is joint director, my lord.
Appointed post director shall be made by promotion among members of the service of district urban. You are serving as what now?
My lord, district urban planner.
Now?
Yes, my lord.
Both
And
the
the other,
petitioners has 2 cases.
yes, my lord. The other petitioner is executive engineer, my lord.
Okay,
What is-
you're a district urban planner.
Yes, my lord.
And I was executive engineer.
Executive engineer. But what is important, my lord, and who possesses PG degree diploma in urban planning, my lord. This is what is the catch, my lord. So as on today, my lord, in the department, there are 3 people who are holding and who are eligible, my lord. But
Would be in his own consideration.
yes,
Yes,
my lord. Yes, my lord.
yes, Mr. Shulai.
I pray for notice. my
Let
lord.
me have instruction, Your Lordship, in the matter. It appears that maybe something is there.
Somebody is against them.
Maybe, Your Lordship. Otherwise, if the DPC had said,
Yes, heard Mr. Philemon Hamudi, the counsel for the petitioner. Issue notice. Ms. Andy Schleiner, AG with MS Zari now can be. Except we have all the respondents. No further notice called for. This up to 3 weeks for affidavit instructions. Yes.
2 weeks, my lord.
motion matter 3 weeks.
Motion matter.
Deeply.
Probably, Your Lordship.
Similar order. in-
Yes, accordingly.
3 and 4, Your Lordship.
Item number 5.
The motion.
May it please, Your Lordship.
Yes.
Lordship, I pray for a short passover, Your Lordship. Mr. Paul is on legs before court, Your Lordship. So let the matter come out the bottom of the board, Your Lordship.
Main list. Item 11.
Boleh kita Okay.
Wait, please, Lordship. Lordship, here, my lord, we are required to file affidavit and pray for some further time, Lordship. We are required to file
You're
affidavit.
not going to file.
No, earlier we had filed an additional affidavit bringing into record the application which was filed. It was substantially
You can
heard.
appeal.
Condonation, regarding condonation, my lord.
Yes.
A single application was filed for condonation as well as recalling the
Supposed to file
order.
separate appeal and also the application for condition of delay.
No, I don't understand. As prayed for the 2 weeks time grant respond. What one? This is what
They're supposed to just file an affidavit.
You filed it.
No,
They have not filed
a
it
full
also.
affidavit, Lordship. I am praying for some further time, Lordship.
You have already filed.
Yeah, filed.
You filed it on the 1st. Have you got a copy of the affidavit filed by 4 and
Yes,
5?
I have received. The primary respondent have filed.
Why you need further time?
Lordship, I am praying for the 2 weeks time, Lord.
Boleh siya one din. Increase. Sebelum siya. Siapa lang? Siapa lang? Vietnam. Where's the affidavit? Okay. Mr. AG Moments on behalf of 415 submits the affidavit has been filed. While Mr. S. Deb prays that we allowed further 2 weeks time to file the same. But he has already submitted 2 weeks, yes.
12.
This matter, this government, they have filed the affidavit regarding the they are asked to file some judgment from the Supreme Court. Which they have filed it, Lordship. So here, what happened in this case, Lordship? Petitioner in their affidavit by law.
1 second.
Lordship.
Where's the release order? In the affidavit?
In their affidavit.
Or it says page initial 3. Yes.
See, Lordship,
What do you have to say to the affidavit? See, number one, you're retired. So you're not very voluntary retirement. Number two, you're not part of that litigation at all. They went, they asked, they sought, and orders were passed. It was only a one-time package given to these people who were not retired, who were released from service. So what do you want with the petition?
Your Lordship, my whole contention.
You won't be covered. Simple as that.
No. My submission is, Lordship, because in their affidavit they have admitted. They said there is a scheme that they never denied.
Scheme was given only for them.
No, Your Lordship.
See, Mr.
Kindly see the para 7 of their affidavit.
Please, not para 7. You read the judgment of the Supreme Court. See, read the page 8. Read this 1, 2, 3, 4 paragraph on 18 February 2019. Read that one. You are bound by order of Supreme Court. Read the affidavit, page 8, 4 para. Read it.
Yes, Lordship. The respondent would be liberty to withdraw. Yes. May I just?
No, read the next paragraph.
Next paragraph.
On 18 February. Read it. Next paragraph which you read just now.
Lordship, yes. On 18 February 2019, this court directed that the status report be filed by the state of Meghalaya, indicating the present status of the person who are working in the Meghalaya Civil Task Force, and in this regard, to the claim made subsequently on 25 March 2019, this court expressed the view that it would be appropriate for the state respondent to consider whether a comprehensive scheme could be formulated.
This is the direction of the Honorable Supreme Court, to consider whether a comprehensive scheme could be formulated to cover all the 50 employees Meghalaya Civil Task Force. See, and will settle entire dispute. According, the state was allowed to formulate a proper scheme and place for the court. So this scheme is specific only to those 50 people who are still in service. Correct? So what scheme are you talking about?
But I'm not seeking parity of those people who have got the.
You've retired. What parity? There's no question of parity. These people were in service, released from service, and so when they came for the court, seeking for some terminal benefits. But the matter went up to Supreme Court. Supreme Court said formulate a comprehensive scheme to cover 50 employees, and so a scheme was formulated, and 1.96 crores was allocated for disbursal among those 50 people, and release orders were issued. So where do you come in the picture?
The Lordship,
the petitioners are all retired, correct?
Lordship, they are retired.
Then where's the question of parity? Where's the question of seeking similar reliefs?
May I just admit, they stated that to formulate the comprehensive scheme, this referred to that scheme which I am referring to.
It doesn't cover you.
But in the affidavit also, Your Lordship, the para 7, they have admitted there is a scheme that is all this comprehensive, all this order and Supreme Court order is based on the scheme, Your Lordship.
scheme was under directions of the Supreme Court that for these people, since they have not retired and released from service, forming a scheme to compensate them.
Now the state have not brought any document whether that scheme was formulated or not. But in their affidavit, they also have admitted, Lordship.
There's no question. There's no question of they do not need to bring it in your case at all. Where's your prayer? Let's see your prayer. Where made a statement that the Supreme Court is? Yes.
No, I'm not asking on the basis of the Supreme Court. I'm just claiming on the basis of the scheme that.
See what you've written here. See, all he's saying is that all you have saying is that the only occasion to casual pioneers, namely so and so, and consequently that to release the wages or benefits entitled when then High Court order, then it went to.
Implement the office memorandum dated I refer in my prayer the office memorandum, not asking on the parity of this
we'll dismiss it.
Yes. Lordship. And there is an observation also from this court only, Lordship, which has not been said as a till date, Lordship.
Everything is merged into the Supreme Court order. That's finality. Okay.
No, Lordship, my
the court doesn't have to explain all this, Mr. Sangma.
I'm not claiming on the basis of the Supreme Court order, Lordship.
Read a synopsis.
My case is different, Lordship.
You're asking for pension under the regular casual worker scheme?
Not for
under what scheme?
Pension, only just some.
What are you asking?
I'm asking that there is.
Then why are you referring? If you're not asking us, then why are you referring to the cases that have no application in your case?
Actually, it's the state who has brought up this affidavit, the report. Earlier occasion, because there was argument, I was claiming the parity on this one.
No.
That's why
now the state didn't bring it up. You have annexed these orders yourself, correct? Of the earlier
that I have withdrawn. Now my
is here in your petition.
But that is the part of the not the Supreme Court order. This is the order from this court, Your Lordship.
You have annexed it, correct?
Lordship.
Then you're saying you're not trying to seek parity with the earlier case.
But this order has not been said. I said, Lordship. This order.
Is that so?
Lordship.
Is that so? Was not appeal carried against this order?
Because in the SNP also nothing is mentioned about this order.
We'll dismiss it and yes, take down. Just the writ petitioners here. Where's your synopsis? Stated to be casual workers who are employed in the Meghalaya Civil Task Force and who have since retired from service. Stop. The prayer as made out in the writ petition is for implementation of an office memorandum dated 16/9/96. Where's the memorandum?
It is page 29, type copy, my lord, in my writ petition.
29.
Lordship, page 29.
Yes. Megafan. Which is the Meghalaya Regular Casual Worker Scheme 1996 to enable them to. Where's the part with regard to terminal benefits?
Yes, page 30, the para 4.
Yes. But then what is this? You under para 4?
Yes, yes.
Yes, no?
Under para 4.
The prayers made out in the petition is for implementation of an office amendment dated 69/1996,
Which is
the Midland Gradual Office
gradual scheme. So, it has been submitted by Mr. P.T. Sang, next paragraph, that para 4 thereof has enumerated the benefits which are admissible to regular casual workers. You said the Supreme Court nothing to do with you, correct?
Lordship.
The Supreme Court orders got nothing to do with you.
Lordship.
Yes. Yes, further
Yes,
submissions have been made that 2 orders have been annexed, wherein an earlier petition, namely WPC number 329/2017, which had travelled up to the Honorable Supreme Court and was settled thereafter with specifically with 50 employees, has no bearing on the instant case. In the instant case, as the same was specific to the 50 petitioners who had come before the court at that point of time. Yes. Where the Mail Civil Task Force Act. What do you have to say?
Task Force Act.
Yes.
Your Lordship, when the Supreme Court order was passed,
That's not nothing to do with Supreme Court. What is the status?
Your Lordship, they have already retired, and para 6 of my act in opposition, Your Lordship, we've already mentioned they are just temporary employees, Your Lordship.
Even those people also
They were very
temporary.
well
Show
aware,
from the
Your
Act. Show from the Act.
The Act, Lordship, I think I have endorsed it. Mistaken.
Meghalaya Civil Task Force. Meghalaya Civil Task Force.
That is under page 23. Page
Yes,
23.
where does it they describe your terms of employment? Mr. Balaji, let us stand. He started arguing. Yes, where does it describe your status? You because you're appointed under this act. Where does it say?
It is para 2, the definition that para 2 government state facilitating the post.
Yes.
2A, Lordship.
2A. 2A says.
Means person. It's covered under the Act section 2A, then the C. Yes, 3 Lordship is there in the 3. Following the consumption. 2 and 3 Lordship is there. 3 it says that state government may rise to maintain the post to be core Meghalaya Civil Task Force, which shall consist of such member as the state government may direct from time to time.
Any rules been made under this act?
Lordship.
Any rules have been made prescribing how much will be paid?
That is not mentioned, Lordship.
Any rules are there or not?
That is not there. And their function
Your
is
Lordship,
mentioned
they
in the
were very well
section
aware, Your
6.
Lordship, when they joined the
No, let him argue. Now you see, because you're appointed under this act, correct?
Lordship.
Now what service benefits does it say? Does it give? What does it say? 6. What does it say?
6 it says that their functions to do any manual work or otherwise connected with construction maintenance and protection, road, bridge, building, canal, embankment, land reclamation or any other development work, to do social work as may be entrusted by the prescribed authority, to perform such as
You see, one big difference, see, Mr. Samaj, to cut your argument short is this. You're asking for benefits under regular casual worker scheme, okay? Will not be applicable to you because you are appointed under another specific act. That's the only thing. So the case for you, not sitting advisory capacity, is to try to make out a case under the act under which you've been appointed. Okay, that is what you... It's not that you're appointed under the Meghalaya Civil Task Force Act where they have the... It's prescribed how you're appointed, what kind of member are you, can be discharged anytime. They prescribe whatever honorarium, whatever pay they give you. So you are members of Meghalaya Civil Task Force, correct? Now you've been discharged since you've superannuated or you... I don't know what benefits are payable to you, but you cannot ask for to be included in the scheme of RCW. Simple as that. The whole case is that only. Your case you ask for RCW is not applicable. It's applicable in other departments where they are appointed as casual workers and they continue to work for more than 10 years. That's all. You understand? I'm trying to get it out of you, but
what my argument is that other people who already they receive on the basis of the scheme, the 50 people there, they have received their amount.
That was just a one-time settlement.
No, that you do not go there. That is Supreme Court matter. Do not go there. It doesn't apply. It doesn't apply to you. Those people, they were discharged before they reached the age of 70. They were discharged. They come for the court saying they didn't get any benefits, and so they said, okay, fine. Since you were released from the force, so a package was made for 50 of you only. It's not to the people who have served the entire tenure, who've been paid their wages till they reach 58 and have been released from service. You understand? And you asking under paragraph 4, it's for it's for other benefits. It's not. It's like for maternity leave, for a festival advance, for some kind of thing like that. Do you want to pass order? Or you want some time to think? Because you have to understand that.
Lordship, I will just take some time. Then maybe come after.
You think about it, because that's the thing. Because you getting, maybe I will not say, maybe there's some way open for you, but the court will not say. But to go on the path of trying to get RCW status since you appointed the act, it will not apply.
Lordship, I understand. Give me only 1 week's
2 days.
time. 1 week's
In the
time.
course of hearing, because I don't want to actually just also get dismissed like that. In the course of hearing Mr. P.T. Sarma, there is not 1 week time to obtain instructions this day after, and so on. So. Otherwise, that is where your case stands.
Lordship.
And that Supreme Court do not bring it in, not apply to you. You were part of that litigation. There's other people who were discharged before that. They had gone and they were given that. It was a compromise actually.
Lordship.
13.
Yes.
What's first, Lordship?
13.
The joint has been filed.
Your Lordship, I pray for some more time to file a rejoinder.
How many times have you taken?
Just once, Your Lordship.
Your name?
GC Marbo. GC Marbo.
Marbo. Is that Mirbo or Marbo?
Marbo, M.A.
That's a correct form. Many people write Mirbo.
Marbo and some.
Yeah, okay. That's paid for by some Mirbo. For 30 weeks and granted for gender activities.
14.
Lordship, I am appearing for respondent number 3. We are filing, Your Lordship, today the application under Order 7, Rule 11.
I've just received a copy of the petition, Your Lordship. But we file application to strike out the respondent number 1 and 2.
No, first,
this case number
7 Rule 11. Who has filed? You already filed. It's already been filed with the Pandey.
Yeah, we are filing it today.
No, it's been filed. Yes.
Just served to me.
This is respondent number
1 and 2.
No.
We are 5 for 3.
711, yes. Respondent number 3 has filed these application as under Order 7 to 11. The same is taken on board. You want to file reply to it? Yes, Mr. So-and-so. Please, I'm allowed 2 weeks time to file.
Your Lordship, 3 weeks.
3 weeks time to file reply set application. Yes, praise God. Yes, next, Mr. H.L. Sangresu on behalf of respondents 1 and 2.
1 and 2.
Yes. Now you don't need instructions. Let me start off. Yes, for striking miss case. Huh? This is a miss case.
Miss case.
It's the miss case, right? Yes, miss case number.
Miss case number.
Praise allowed for 2 weeks in the for miss case. Huh? Where is miss case number? Sorry.
Miss number 22.
Yes, miss 22. There's an application for striking off the respondents 1 and 2 necessary parties as parties from the array of respondents in the petition. The same not objected to by the petitioner. In this case, only stands allowed. In the main case, review the order allowed, and in this case disposed of. In the main case, review the order passed. In this case, so and so. Registry to correct the array of parties by deleting respondent 1 and 2.
Obliged.
Obliged.
15.
What's the affidavit we have filed? Well,
yeah. What affidavit is this?
Well, they had brought a letter on record, Malats, by which there was a purported Malats. My apologies, Malats. My apologies, Malats. I tender my apologies.
Yes.
Malats, your lordships, the KHATC had brought that letter on record, Malats, by which there was a purported rejection. I'll draw your lordship's attention to that order, Malats. 5/7/2023, if your lordships kindly have that.
5/7/2023. Yes.
This was the letter dated 2nd of September 2021.
Yes, yes.
So, Malats,
you file affidavit also.
Against that, Malats,
what do you have to say?
Malats, there are two aspects to the matter, Malats. One, the permissions that the necessary, they say, Malats, that the necessary permissions from the CM-ship as well as the other authorities were not there, Malats. That is very much available. We brought it on record. The other thing is, Malats, your lordship would kindly have a look at that letter, Malats. This lordship.
Your lordship.
Yes.
I may assist in that. Can I please serve a copy of the affidavit? I was under the impression that they are yet to file. And I'm not ready with the hearing today because of my personal difficulty and health-wise. So, if you can come some other day, Your Lordship.
No. I'm informed also, Malats, they could not serve it on the.
We could not serve it. Mr. Vijay Kanta, like answer respondents.
Please, Lordship.
Submits that, yes.
My apologies. Lordship, there was some miscommunication with Junior's Lordship. I couldn't file my affidavit. I request for 1 week's time to file my
What affidavit you have to file?
My counter affidavit, Lordship.
State has not filed a counter.
You have not filed?
Not yet, sir, Lordship.
Okay, reply affidavit. Let's take down his reply affidavit by the petitioner to the letter dated 2/9/2021, which was brought on record by the Respondents Council has been since been filed. Stop. Message Karwanlang for respondents number 1 and
number 1 to 3.
1, 2 and 3 submits that praise him allowed further 1 week's time to file the affidavit. So, accordingly, this is a matter after 1 week for consideration. Make it simple.
Much better.
16.
Please, Lordship. Lordship, similar prayer in this matter. Lordship, the affidavit is ready and you have to file.
Private respondent have filed, Lordship.
Yes.
All the private respondent have filed. Only state.
Mr. H. Karwanlang, praise the email. How much?
Lordship, this is 2 weeks' time.
Why? This is a okay, praise email out for the 2 weeks' time to file affidavit on behalf of respondents 1 to 4. Stop same is allowed. The MSP Baswara Kama Council response for appearance response number 6, 7, 9 and 10 submits that the affidavit on behalf of the response has been filed.
Lodge
after 2 weeks.
17.
I'm praying for some more time to file the affidavit. And for the respondent 5.
5.
5.
What about 1, 2, 3?
After the respondent, 1 to 3.
Yes, you file affidavit. What about 6?
Note 6, I've already made a submission.
No affidavit will be filed, yes. So anyway, Mr. A Moment, then it Vice Mr. SN. Are you in the panel also? Mr. A Moment, GA. On behalf of respondent 1, 2, 3 and MSR that Council for respondent 5 brief and allowed further 2 weeks time to file affidavit. Yes, is that after on some?
Yes, Your Lordship.
What happened to the
Service report is still awaited, Your Lordship.
Oh, you should say that. Receive. When you file service affidavit, Mr. D. Hinyota, a consular petitioner, prays him allowed to obtain status of service respondent number 4. Yes.
All right. 18.
May I please, Your Lordship?
Yes.
Your Lordship, we have received paravise comment just yesterday. So another 3 weeks time may be given and that will be final, Your Lordship.
MS as well as he submits that the instruction just will receive. She prays for and allowed 1 second. 3 weeks time to file. Your payment for number 5.
No, we have 17 in
18 is
connected matter.
Your paying the next matter. 1 second. Yes, sir. Problem. Yes, prayer is allowed. What about number 5? They have been served. None appears on number 5 today also. Stop. In the next matter, instead of as Barashi, you should give your name. Next matter, you are paying for 1, 2, 3, 1 to 4, and they have been served. Number 5 there. We need to wait. You are with Miss SD.
Yes.
Okay. Same thing for a moment 1 to 4. Yes, same. Number 5. Now that we are number 5. Yes, also.
20.
May it please, Your Lordship. Lordship, I've received instructions in this matter, Lordship. And on the last date, the point of non-receipt of salary was raised, Lordship. Lordship, as per my instructions, Lordship, there was an application for extension of leave as leave without pay. So, Lordship, let me file my affidavit, Lordship, to clarify that point.
Zero pay. What happened?
Hey, my lord, I haven't received pay for 18 months, my lord. So that is also one problem, my lord. That's just an additional problem. Main is regarding the transfer, my lord. Let her file an affidavit. She's short time for it.
Yes, MS Indishra Senior GA submits an affidavit, submits that appraisal she will allowed to file. She prays if you allow further time to file affidavit. Upon this 2 weeks time granted, less thereafter.
Much obliged, Lordship.
Second call. Item number 1, main list.
Yes, Mr. Kumar. Yes, you're audible.
Yes, Your Lordship, I have checked, my lord. The statement is outright incorrect statement. This is an appeal preferred against the tariff order of 21-22, my lord. That's why I called the law officer also. And Mr. Paul is saying that the order has been challenged before appeal without verifying the fact. I have called the law officer is present, my lord, and this is the appeal preferred against the tariff order on 21-22. And Mr. Paul is making the statement that we have challenged the review petition, my lord. That statement should not, is very unfortunate, because I was taken by surprise, my lord. That law, and without, this is an appeal preferred against 21-22. We can't mislead the honorable court. My lord, kindly see paragraph 1 only of my petition. Paragraph 1 and 2, my lord. How the MPRT has conducted. Paragraph 1, page 17, my lord.
Paragraph 1.
Paragraph 2 of Para 2 of my petition, my lord. I will read through it that the order dated 11th July 2023, my lord.
Yes.
Got passed by the learned chairman of respondent Meghalaya State Electricity Regulatory Commission in IA number 1 of 2023 in MSCRC tariff review financial year 23-24. Review case number 9 was passed without affording the opportunity of being heard to the corporation. While notice dated 3rd July, MSCRC has listed IA number 1 to 10 of 2022, previous IA of regarding. The IA number 1 to 10 of 23 was taken up for hearing. On being objected by corporation, the MSCRC has agreed during the course of hearing to fix the matter on some other day and further granted time to corporation to file the counter affidavit to additional affidavit filed by BIA on 3rd July. However, to the utter shock and surprise of the corporation, MSCRC has wide order dated 11/7/2023 passed an order on the matter which is not even taken up for hearing, that is IA case number 1 of 10 of and tagged along with the matter of 1 of 2022, and it goes on to record submission that has not even been made by corporation during the course of hearing. It said act on the part of his in violation. I can file the affidavit in support of this contention. Affidavit is already there, but I can ask the lawyer concerned also to make the statement that the IA was not taken up, he was not heard, and his presence is being shown in the impugn order that he was heard on the IA. Now, this is what we are speaking, my lord, is on the superintendence of this honorable court over the tribunal, my lord.
Yes.
And if your lordship will see the impugn order, his presence is being shown, his argument is being recorded without there being any.
How can you make a statement like that at the bar? Is that correct? Who appeared before the tribunal?
I can get the affidavit of
the lawyer.
He was present. The matter was heard.
Kindly see.
And there is a reply filed by them.
Yes, yes.
Bring that reply on record.
Continue.
My lord, I can file I have given this statement on oath, my lord, and I will give the statement of the lawyer also at page 39. Your lordship kindly see page 39 of the impugn order. If this is the problem which we are facing, my lord.
39.
And if your lordship will see at page 40, date of hearing is 4th July 2023 and date of order is 11th July 2023.
Yes.
And on oath I am saying that the MSCRC did not hear the corporation on this review petition or in the IA filed in the review petition, my lord. MSCRC agreed to defer the matter.
Where is that recorded?
Your lordship,
that is
in my statement. In the order it is being shown that I have argued the whole matter. That is my grievance, my lord, before your lordship. So this is a gross case of violation of principle of natural justice, my lord.
Now you say that on 4th of July,
yes, sir,
the hearing was on different IAs altogether.
Different IA, and
which
even
were those?
cause list is not. Even cause list is not prepared by the MSCRC, my lord. There is no cause list, nothing, my lord. No daily orders are uploaded. And my lord, hearings are recorded also, and we can place that on record also, my lord.
Recorded, you mean recorded by video?
On VC.
It's through video conferencing. The records are kept by the commission.
And we have made a prayer for recording.
See, we are approaching very shaky territory because this is a thing. These are very serious allegations
against the statutory commission.
Whatever against the presiding officer. I mean, in the conduct of the tribunal.
Their objection is on record.
The court takes cognizance of this, then it calls for, it's.
Because the fact of the matter remains, well, as they have filed an objection.
Your lordship, they talking about this matter. My question is whether this matter was taken on 4th July or not for hearing.
I think you require an affidavit. If you want to maintain these allegations, then
Then the chairperson would also have to be made a party personally, because you are alleging malafide.
We are filing separate contempt against chairperson also because it
Contempt
is in
for what?
gross violation of your lordship order. Lordship said that a single member
Contempt
can't
of
decide
his,
the matter.
contempt of his chair or contempt of the order of orders of the court.
There are two things, my lord. One is I am here before your lordship in 227 on superintendence on the tribunal, my lord. If the tribunal is not performing the function, your lordship has got ample power in Article 227. So I have
No, that's a given. It's not that. It's just that the allegations that you have made, or the point you have raised,
I can place, my lord, I am instructed to say that I can place that also on video, the transcript of the conference. What has
transcript is of the commission. I don't know how.
Because under Article 227 it can be summoned. If my friend is disputing that no, my IA was heard, let his statement be recorded.
You put an affidavit.
Let them file an affidavit.
Put an affidavit.
And
I will put an affidavit if that is the situation, it has to come an affidavit, because it's only a statement para 2 that you.
This is supported by affidavit, but I will have the independent transcript and everything. And let the statement be recorded by the counsel, learned counsel, senior counsel on his instruction. If he is making statement, no, this IA was heard on 4th July, then the perjury will be committed by my client. Or perjury will be committed by his client.
Let them file the affidavit. I will file a response within a day's time.
There will be perjury by either my client or his client.
They have gone on affidavit bullets in this petition saying that they have not filed a response. They have not annexed it. I have gone and got the file, Mills. This is a response file by them.
Whether the IA was heard on 4th July or not.
And your lordship will see whether there is a response on the IA or not. I will not get into these arguments.
Or it was deferred. And on 11th July, order is passed as if the
if you want to maintain allegations that he was not heard, then you have to find affidavit. If you want to sidestep that and go to other points,
I will place it before lordship. Now
okay, then that is.
I will lordship may grant me a day's time to respond, Mills.
Yes, Mr. A. Kumar Leonard, senior advocate, stroke advocate general, appearing for the petition.
And the lordship may also
at the outset raise serious issues with regard to the conduct of the proceedings before the Meghalaya State SD Regulatory Commission, and has submitted that on the date
on the 4th, my lords.
Submitted that on 4/7/2023, the interlocutory applications in question were never. The petitioners were not heard, but the name of the counsel has been recorded in the impugn order, as also the arguments made therein. Stop. Next, to this end, he prays him Lord to bring these statements on record by way of affidavit, which is permitted by this court, apart from any other issues connected to this statement that may be relevant. So,
Your Lordship,
how much time?
Only 3 days time, my lord. Your Lordship, kindly see page 35, my lord. My prayer 35, my lord.
No, we won't go to the prayer now, since you filed.
Only one limited, last, my lord, one interim relief.
Preserve the recordings.
Your Lordship may be pleased to add interim order directing to preserve and produce video recording of hearing, because video recording is maintained, my lord. That is the best evidence.
No, that we'll look at that later on. Yes, sir.
Your Lordship, video recording is there by MSCRC. They should not destroy. That's the only.
No, let them produce you file affidavit first. We'll examine. Then if we find some material in affidavit, we'll ask for the video recordings. We'll not jump the gun. Yes. No.
3 days.
Statements on record by way of an affidavit, which is permitted by this court apart from any other issues connected to the statement that may be relevant.
Yes. Accordingly, 3 days time is granted, and further 2 days time to the respondents to reply to the affidavit. This accordingly on 3 days will be because this is very serious, Mr. Paul. The thing is that this is.
I was present for the hearing. How can we make a statement unless the matter is not heard?
Order has been challenged. That every time they will mislead.
See, the thing is that, it's very limited revision. If it is not on grounds of jurisdiction or, patent, malified exercise of power, then under 227 will not entertain it. You have recourse for appeal. But if you have other grounds, that's the only thing, yes. Because we can't go against order of division bench if we have to maintain judicial discipline with regard to.
Supreme Court, because this order has attained finality. Because they challenged the order of the division bench before the Supreme Court.
I will argue on the merit also,
Right.
so nothing has attained finality.
Yes.
Because you have filed review, on review there is no order.
Supplementary list, second call, item 5.
May it please your lordships.
Yes,
My
Mr.
lord,
Singh.
in the case, my lord, of the university, my lord, the case of the writ petitioner here, your lordships,
What is this? From which website?
that he had applied for the post of professor
Zoology.
Zoology, your lordships. Now, my lord, it is an admitted position that after screening he was found eligible. It's not that he has been screened out. He was found eligible, called for the interview. Now, after that, what happened? On the date of interview, my lord, while making interaction with other candidates, he came to know they did not have the requisite qualification. And that's how he rushed before the court, and two contention he raised. He has set out a chart. In the chart, my lord, what transpired from his interaction with the candidate, you see, these people do not have geology background, so that should not have been qualified and called for interview. That is the only limited grounds, and so his prayer, the selection process to be satisfied, and in the meantime to be halted. Now, my lord, while looking into it, of course, all these candidates, they were made parties here as private respondents. So at the time of lordship, my lord, looking into the facts and situation, lordship has not granted any interview. Further, my lord has not even issued notice on the private respondents.
Yes.
Only thing, limited thing, your lordship has asked me, directed me to obtain instruction, not affidavits. Well, I took the pain. I consulted the concerned authority of the university. Then on the basis of the matter, how, just for your lordship's appraisal, my lord, how the selection has been made. Now there are a selection committee. Now, my lord, they are comprised of the experts. They look into the matter once the applications are filed, who are eligible, who are not eligible. Then on the basis of the interview, they only made recommendations. And this recommendation is placed before the executive council. This is as per statute 20 of the university. Then after deliberations, my lord, if the recommendations are accepted, now executive council may not accept the recommendation. There's a different thing. Only then appointments are made. Now, my lord, these selection in that which stands, my lord, has not yet concluded. My lord, I do not know, these are right now in seal cover. Even then from the records, my lord, I have prepared the chart with regard to their qualifications. Now, my lord, before I place the charts, my lord, few things I need to clarify. Now, we are concerned with geology. Now, admittedly, my lord, geology department belongs to the School of Life Science. Now, this is also called bioscience. Now, my lord, as a layman understanding, my lord, what is life science? Life science that deals with all living things, starting from, my lord, microorganism to animal, plants, all that is living, my lord. So that is the purpose of life science, my lord. That's what the life sciences deals with, and it has various branches, my lord, in geology, botany, etc. So in NEHU, we do have a School of Life Science. Now these comprised of, my lord, they have annexed. Lordship, if I can take my lord to the last page, 57. School of Life Sciences. 57, my lord, in the first column, your lordships, first, second, third, written in bold.
Yes.
Lordship has got it, School of Life Sciences.
Yes.
Now, there is a department called Biochemistry, then Biotechnology and Bioinformatics Department, Botany Department, Geology Department. So these all comes under the School of Life Science.
Yes.
Now, my lord, what I want to convey, my lord, these departments are not stranger to each other. They are either allied, concerned, or relevant to each other, because they all belongs to the School of Life Science.
Okay.
Now, my lord, I'll take, my lord, what are the requirements, essential qualification, my lord, laid down by the UGC. Lordship, your lordship kindly come to page 3, my lord. these contain the extract of the, my lord, UGC regulation.
Of the writ petition?
Of the writ petition, page 43.
Page 3?
Page 43, sorry.
43.
40. This is an extract from the relevant regulation of the UGC containing the essential qualification for professor.
Yes.
Well, Lordship will kindly come to the bottom.
3.
Roman 3, Your Lordship. Professor.
Yes.
Eligibility either could be what is prescribed in capital A or B. Now A, my lord. Lordship will, I'll read it out.
Yes.
A1, an eminent scholar having PhD degree in the concerned / allied relevant discipline. My lord, the choices Your Lordship will see. Discipline and published work of high quality, actively engaged in research with evidence of published work with a minimum of 10 research publication in peer-reviewed or UGC listed journal and total research score of 120 as per the criteria given in Appendix 2, Table 2. Now, number 2, under A minimum 10 years of teaching experience in university, colleges as assistant professor, associate professor, and or there is an option here, Your Lordships. It's not necessarily only teaching experience. There is an option here too, that is, or research experience at equivalent level at the university / national level institution with evidence of having successfully guided doctoral candidate. Now, experience could be either in the field of teaching or it could be in the field of research. Now, my learned friend is saying that they do not have that requisite qualification of teaching.
Yes.
Now, Your Lordship will come the alternate qualification in B. This is meant for those who are, my lord, industrial background, or an outstanding professional having a PhD degree in the relevant / allied / applied discipline from any academic institution not included in A above / industry who has made significant contribution to the knowledge in the concerned allied relevant discipline supported by documentary evidence. Now, Lordship might have noted here. Here the requisite qualification is PhD, not the master degree.
Yes.
PhD in, Lordship, they have given the concerned, allied or relevant disciplines. Now, my lord, now who will determine this concerned, allied and relevant? My lord, as a layman, I cannot.
Expert body. Yes.
It's for the experts. Now, my lord, do they have this requisite qualification, my lord? Based on records, we have, university has prepared a chart and I am placing the chart before my lord. This is for the court. Well, this is at this stage I am not supposed to share with. These are entire thing is still covered. Since Your Lordship wanted instruction, my lord, I am placing it. Now, my lord, there are as many as, my lord, 9 candidates were called for interview, including the petition. Now, my lord, candidate number 1, unreserved. Now, he has done his MSc in biotechnology. Obviously, biotechnology again belongs to the school of life science, but that is not again a relevant, my lord, requisite qualification. What is requisite qualification, my lord? Will come to the next column. He has done PhD in life science from Jawaharlal Nehru University, Delhi, and he has a specialization in molecular biology. Now, Lordship will see on the top we have written what are the specialization required. He fulfills. Now, my lord, will come to number 2. Number 2 is Manaskumar Central Unreserved Chemistry. Now, here Your Lordship may ask, they do not belong to life science. But then Lordship will look into his PhD. PhD in Biosciences and Bioengineering, IIT Bombay. Now, these again, my lord, a requisite condition. Now, the question obviously, Lordship, if he is not from, my lord, chemistry is not from life science, no, whatever. Now, my lord, general chemistry will also include biochemistry. And to qualify, my lord, in a requisite field, relevant field of the bioscience, he should have enough knowledge to be registered as a PhD, enough knowledge of biochemistry. So, my lord, that he has been registered, and my lord, under the supervision, he was found fit, and that how, my lord, he has been awarded this PhD. Now, my lord, number 3, he is in biochemistry.
Okay.
Now, again, my lord, PhD in biochemistry. These are all relevant, my lord. specialization molecular biology. Now your lordship, next, he has done, my lord, only geology master degree. Then he has done his PhD, the same subject from Guwahati University. Then specialization in animal physiology, biochemistry. So these are all relevant. Now next is the petitioner. Now he has also been qualified and called for the interview. He appeared. Now my lord, we skip the writ petitioner. Then comes my lord number 6. He has done in geology. Then PhD in geology from Viswabharati University, specialization fisheries. So my lord, next number 7, bioinformatics. Now bioinformatics again my lord, School of Life Science. Now PhD in biotechnology. Now next my lord, 8, he is in geology and PhD in geology. 9 my lord, unreserved, he has done in geology, PhD in geology. Now my lord, lordship will see other thing my lord. The lordship come back to page 1, the last column, regarding my lord experience. Experience either could be teaching or research. Now lordship, we have my lord calculated and put in that column my lord requisite length of their research period.
Yes.
All my lord above 10 years.
Yes.
Well above 10 years. All. Now my lord, in this situation my lord, I am unable to understand my lord, when he himself appeared, he is not alleging malafide. He cannot allege malafide against the committee because he himself qualified, appeared for the interview. Only basis of some interactions my lord, he set out certain qualifications my lord, which are not relevant and which are not correct. Now my lord, if your lordships my lord, to be clear on this subject my lord, if your lordship come to page 3 my lord, same chart. Now there are instances in the same department my lord, who has not done their master degree in the same subject, but your lordship come to page 3. We have cited some example in the School of Life Science my lord. Lordship has got it my lord. Number 1, Professor Anupam Chatterjee. He is MSc and PhD in geology, but he was employed where your lordship? Department of Biotechnology and Bioinformatics. Though he is from geology my lord, since he had the requisite qualification PhD, he was engaged in Department of Biotechnology, another department but under the life science. Similarly, Professor A. N. Rai. Now these men went on to become the Vice Chancellor of the university at one point of time. Now he had MSc, PhD in botany, but he was appointed in the Department of Biochemistry, from where he retired in 2021. Now lordship will see next. Similar my lord.
Botany.
All this list my lord speaks in volumes. Now if we go by what my learned friend is saying, we will have to nullify all these appointments. So my lord, this UGC regulation is very clear, very categorical my lord. MSc is not a requisite qualifications. What is requisite qualification? PhD in the concerned, allied or relevant. Now my lord, I have briefly my lord a layman understanding of lifestyle I have placed before your lordship. Now rest it is for the expert your lord. Now my lord, my only concern my lord, I am insisting my lord to close this matter because there is a misinformation complaint, the entire thing under scrutiny before this court. So these build up undue pressure my lord on the selection committee, on other authorities. So my lord, this is a fifth case my lord. I will make a submission your lordship. Lordship has not issued notice on the private. Lordship will dismiss this case and at least a token cost will be imposed.
Yes, Mr. Paul.
Firstly, I am my lords required to bat blind my lords.
Meaning?
Because whatever is there before your lordships, whatever is there before my learned friend my lords, I am not privy to it.
Will not be disregarded.
I'm sorry, my lords?
Will not record it. Will disregard. You have not shown him.
No, my lords.
Please, these are my just for
my lords, I don't understand my lords. What my lords, academic qualifications, what confidentiality can be there to that?
It's an element of mystery to put you off guard. Yeah. Yes.
Two things, my lords. I'm only saying, if the university is saying, my lords, that the selection committee has gone about the exercise of identifying, my lords, rightly said, they are the experts. They feel, my lords, what has been submitted before your lordships, even though, my lords, there are certain issues, I will not come into that at this stage. Even though, my lords, there can be this question, if university is saying they are otherwise eligible, let them simply just put in an affidavit, my lords, that they are eligible. The scrutiny has been done because they are eligible.
See one thing, Mr. Paul.
Matter ends, I don't have any case after.
We can't hold up selection.
I'm not asking for the election.
And if the submissions, they said it has some value in the sense that, once a matter comes for the court, the whole,
my lords, I will go a step further.
So let us clear these things.
My lords, if your lordships permit me, my lords, I will go a step further. I will invite an order from your lordships, my lords, saying that since the statement has been made before this honorable court that all of them are otherwise qualified, they should proceed with the qualifications. Let it be on my prayer. I have no difficulty with that.
Then we'll pass order accordingly.
I am only submitting that whatever they are saying on a sealed cover, if I am saying somebody does not have the requisite qualifications, if that is incorrect, simple thing to do is this has to come by way of an affidavit from the competent authority of the university saying no, we've gone through the procedure, they've been found competent, matter ends. Insofar as
we will just record that extract of the records have been produced for the court and shown to the counsel for the petitioner.
Your lordships will appreciate that this kind of thing, I cannot take it on my.
You don't like the seal cover procedure.
Your lordships have now said, the seal cover procedure has to be done away with. In courts, we cannot have seal covers. Two-line affidavit can come from their side, saying that they are all qualified. I have no difficulty. What, if they are qualified, I just pause here to ask a question to myself, if they are qualified, what is the difficulty that some authority of the university has in filing a one-line affidavit?
You can't compel them.
It cannot be at this.
Yes, we'll pass orders.
He himself appeared and now he is questioning it. Who is he to question?
Take this back, Mr.
No, this I am officially not privy to.
No, we're not. Yes. Take it back, yes. We'll pass orders.
Yes. My lords, I am only praying, and my prayer
will recorded.
Your lordships.
All right. Yeah.
Because, I cannot be expected to, somebody comes, it's not even an affidavit that is there filed by the university.
What
they
stage
simply,
it is? What
they
stage
come and
it
say.
is? Lordship will appreciate what stage it is.
Anyway,
Lordship has said,
if they are,
opt-in instruction. I have opt-in
if
instruction.
they are,
and how he is concerned with other qualification, I could not understand.
What I am amused at is, if somebody is qualified, what difficulty does the university have in saying that he is qualified? Unless there is something to hide.
No, not at this stage.
It's at this stage.
If your lordships permit me, yes. what was being submitted before your lordships is very interesting. Now we've seen, there was this very interesting justification given. Life sciences, allied, everything is allied. So his PhD is to be considered. That very page, your lordships very quickly just glance through. Chemistry comes under which school, my lords? Your lordships may kindly very quickly just have a glance.
Mr. Paul, we'll pass orders.
No, my lords may just bear with me for 30 seconds. I'll just take 30 seconds of your lordship's time.
The thing is like this.
My lords.
The order reflects that this matter has been decided by an expert body. We're not going to send an appeal for this in expert body who to call. At a time of selection, let the selection go ahead. You have any grievance, the field's open for you. That's all. And if you subject yourself to the selection process, then whether you want to impugn it now, then you have no case. But if you want to go to the selection process, that means you have to face the consequences, and then you turn around and challenge it. Because you already on record your petition that cannot be taken from you. So that's it.
No, then your lordships would also,
we agree.
Your lordships would also record
that
the university is resisting filing an affidavit.
Court has not asked me.
No.
We
will record that we have demanded an affidavit be put on record from university showing the eligibility of the private respondents.
My lords, I am only submitting this.
Whether your lordships we have not even issued notice.
Whether your lordships would only consider this.
Yes.
Your lordships, writ proceedings are summary proceedings. Summary proceedings, my lords, cannot be dealt with submissions made off the bar, my lords.
No, this will be observations of the court. It's the view of the court.
Your lordships are at liberty to do. What I'm humbly submitting is that my contentions, what I am saying, is not refuted on affidavit.
Right. We'll let it
go. Honestly, I'll point out what my learned friend is saying. The court need to pass an observation. If he has a grievance, he can approach. He need not make your lordship. He knows, my lord, what is right.
I did not say that.
Not supposed to guide him.
I did not say that.
The court is not saying we recorded. I said that is. I was just saying the court is saying, observing that if he has a grievance, he's challenging the process now.
This is absolutely premature. They should not have come at this stage. Lordship will impose a token cost.
Item 1.
Dr. Mozi, I received a copy of the petition. What is this?
It's gone to different tangent.
See, you see, because before permitting them to unlisted motion, I'd asked for the impugn order. And you see that page 58.
Para 8, last page. That's one right here.
Paradigm.
para 8, Assam Rifles is given NOC. Correct. Now para 9, now another CPF is.
That too after receipt of our legal notice, Lordship.
I'm afraid we have to take instructions.
But now it's gone to a different authority, my lord. As far as Assam Rifles, my lord.
You made them party, BSF?
Lordship.
Yes. Then
this is not
Not BSF, Lordship. ADG we have made a party because BSF
Why?
has recommended. ADG is the appointing authority, Lordship.
Okay.
Lordship will pass a status quo order, Lordship, against the post where I was transferred and posted. From 19 it was vacant. Now suddenly, after the division bench order.
My lord, we do not know, my lord.
Let it be the status quo. Just get instructions.
Yes, status quo.
Yes, this petition's continuation of many rounds, earlier 2 rounds of litigation with regard to the transfer and posting of the writ petitioner. Stop. Where is he posted now? Currently?
Lordship, now he is in Sukhovi, Lordship, in Dimapur.
Who's present? Who is an eye specialist presently posted at Sukhovi, Dimapur since 2008.
Lordship.
Yes. 1 second. Yes, the grievance of the petitioner at this juncture is that while the Assam Rifles, while a communication dated 15/3/2023 had issued an NOC for transfer of the writ petitioner to the composite hospital BSF at Patgaon, Guwahati on interforce transfer in compliance of the orders of this court dated 31/1/2023, the BSF via a communication dated 7/7/2023 has however recommended, the name is not given.
No name has been given. Just they have informed us after.
Has recommended another doctor, bracket eye specialist, for transfer to said post. So, the impugn order dated 24/7/2023 is annexed Annexure 8 to the writ petition stamp. M. Bodloyan.
Lordship.
Yes, sir. Next one. MS M. Bodloyan submits that the action of the respondents is to frustrate the orders of this court, especially when they were supposed to take decision on a policy, correct? The same one.
Lordship.
Yes, especially when they were supposed to take a decision on the policy applicable. Stop. She prays that in the interim, she prays that the interim, the said impugn order be stayed. So, what do you have to say, Dr. Ambuzika? Submits as the matter has been brought on today by way of unlisted motion, he may be allowed to obtain necessary instructions. Stop.
For the timing, I'll appear only for 1, 2, and 3 minutes.
Yeah. He further submits that for the time being,
1, 2, and 3.
he will be representing only the respondents number 1, 2, and 3. Should we issue notice to them?
I'll have instructions.
Yes. Stop. Anyway, next paragraph. In this view of the matter, as it appears that there is some urgency which will detrimentally affect the writ petitioner, it provided interim status quo should be maintained As to the no
That's
status
the
quo.
post,
We should
Stay,
suspend the order.
Lordship.
It concerns only him, correct? Or someone else.
Lordship. Order may be
We
suspended.
don't know whether he has already joined or not.
No, not joined.
Status quo will do, my lord.
No?
Order can be suspended and status quo as regards the post.
That till the next date, status quo should be maintained with regard to the postings.
Because in case
Just a
of
matter on?
status quo.
Let's not for 10 days.
In case of status quo, they may make her join in the
Backdate.
at the backdate, Lordship. That is the problem.
Status quo as on today at 12:20 p.m.
Lordship. Much obliged.
Hearing.
He is there. He'll advise them. Yeah.
Hearing supplementary list item number 6.
May it please your lordships. Only just 5 minutes, my lord. Few clarifications, my lord. I have otherwise concluded, my lord. Few clarifications. Now, my lord, as I was submitting, my lord, the impugn order, my lord, after making the settlement was finally made, your lordship. I just show, my lord, in the meeting they have resolved to appoint me. So that was final. But I was asked to obtain a suitable land. So, my lord, what is the specification of the suitable land is not mentioned. So what I did, my lord, these pleadings are there in my affidavit. What I did, my lord, at that point of time, within the earlier round of litigation, they were vehemently saying the land offered by the bidders, which bid was ultimately disqualified by this one.
Should we go there or looking at the actions of the...
My lord, it's very
because
suitable.
the only thing, the basic thing you have, Mr. Sen, is that the cancellation without hearing you, correct?
Exactly, my lord. No, another thing is that is there, and other things. One, the settlement has been made, and you asked me to get a my lord, suitable land. And what land I got, your lordships? The land offered by the earlier lessee, your lordships. And lordship, one more thing I have made in my pleadings. This land was during the pendency of first round of litigation. District Council was operating from that same plot of land because they found it very, very suitable and feasible. So, my lord, without going into further confrontation or coming to the court, they should not have imposed a fresh condition, my lord, to get a suitable land because I was qualified on the basis of what I submitted. And lordship has also held. I obtained that land. After obtaining this land, my lord, what happened, lordships? These dates are very crucial. My lord, what happened, your lordships? 1810-2022, my lord, they resolved to appoint me. And they asked me to get a suitable land. And this was communicated to me on 26/10/2022. This was communicated to me. Now, my lord, I obtained a land, communicated to them that I obtained a suitable land. Now, these fall, though that specification is not, fall on the left-hand side from Juai to Shillong. Now, my lord, what happened? They were silent, and your lordship will recall one thing, my lord. These happened in November. My lord, October. My lord, they have appointed me. Now I obtained the land, submitted all the documents. They were silent because that period, my lord, the general election was held. And ultimately, my lord, government was formed sometime in February. Here the problem started. Government was formed in February. Now, my lord, what they did, 14/3/23. Now, my lord, I lost their favor. I do not know, my lord, change of incumbents, many things could have been there, but the way they have been done, they cancel my settlement, stating only reason the legal notice by the answer.
Now you're saying 18/10/21. They appointed you?
No.
Or 22?
No. I was appointed in, my lord, in a meeting held on 18/10/22.
22. You said 21 earlier.
Sorry, your lordships. Because after the judgment rendered by your lordship. Lordship has rendered the judgment in first round of litigation on 26/9/22.
Okay.
And the first writ petition was filed in the year 2022. That was filed, general election was held, they were silent. I lost their favor, my lord. Now I am out without rhyme and reason. Now they have come up with many reasons. Now one of the reasons shifted. For decades they were operating from there. First round of litigation was there. They have never uttered a word that they have an intention to shift out. They could have said this. Their affidavit is there, my lord. Totally silent. They were saying that most suitable place, the land offered by the person whose bid was disqualified by your lordships. They were saying all throughout. Now, my lord, I could not understand. I was appointed in 2022. Now, thereafter, it was cancelled, my lord, without giving me an opportunity on 14/3/23. And immediately, within, my lord, 10 days, they found, what they found? That this place is no more feasible.
It's cancelled on 14/3/23.
My lord, the meeting held on 14/3/23 and communicated.
Cancel the contract, no?
Cancel. Yes. And this was communicated to me by letter dated 16th March 2023. And thereafter, how they have taken a decision, suddenly they say, transpire from the affidavit that this is not feasible, we need, and where they have shifted, because Lordship has one reservation, though my lord is prima facie satisfied, that's what I understand, the cancellation after appointing, cancelling, because I have done my part, appears to be wrong. Now, only reservation your lordship thinks might have changed. So, because of the change of the situation, perhaps what relief you want. Now, what change has taken place? On 24th, my lord, they suddenly say that this place is not suitable, and they shifted to a place called Claytitsy, just 5 kilometers from the initial spot where I sought to set up the wave. Just 5 kilometers. Yes. This is just in the vicinity of Mukindur only. Now they set up, and what they are saying, but that is very important, your lordships. They are saying that they are running it departmentally. That statement is there in their affidavit, your lordship. They are running it departmentally, but by engaging a commission agent. What actually happened, your lordships, they have handed over this bridge, entire bridge, to this agent. His name is there. I have not made him a party because he is a middleman broker going by their allegation.
That is plain to see, but hard to put down. That's the only thing. Lordship. Departmentally, you can put anybody. So anyway,
they are saying they are departmentally. So if your
council,
no, my lord, even if your lordship interfere, my lord, restored my appointment and asked me to, my lord, asked me to operate, no prejudice will be caused to them. And the other thing, perhaps, my lord, there
can a manage such issue?
Lordship can, your lordship. If there is, my lord, this kind of thing has happened,
yes,
lord, I will reply. And the other thing, my lord, yes. last submission, my lord, perhaps if there was a general policy of the district council that all the waivers will run department, it is not so. Because they are saying one more thing, that at one point of time, government has issued a letter questioning the jurisdiction of district council to set up wave bridge. So they have filed a case and some kind of interim order is there. That matter is still pending. They are pleading in their affidavit. Now what happened there, your lordship? In spite of this, my lord, Sunapur date to have a wave bridge. That has been leased out.
We're not going there. The only thing which will limit to your case only, and like because
no, because that is in writing. Suppose if they say, that's all.
Yes.
Well, facts are not much in dispute, my lord.
Yes.
The only question now is the entitlement of the writ petitioner, my lord.
Yes.
And that whether a mandamus to that effect can be suitable.
Yes.
My lord, in the earlier round of litigation, my lord, your lordships have directed, your lordships kindly take up my affidavit, my lord.
Yes.
With the respondents, my lord, on 19 June 23, my lord.
The affidavit filed in this case. 19 June. 26 June. Oh no. 19 June, yes.
19 June. Yes. What is your lordships directed at that point of time, my lord? I have quoted in para 5, my lord. Subpara 14, my lord. It is further provided that as the NIT did not prescribe specific criteria and requirements to meet the norms of setting up rules.
Who are you reading? Para 5.
Para 5, I have quoted, my lord. Your lordships order, my lord. Page 3, my lord.
Yes. Where the NIT?
Para 5 internal para 14, my lord. The
Okay.
quoted para 14. Yes. It is further provided that as the NIT did not prescribe specific criteria and requirements to meet the norms of setting up police stations, the respondent number 3 is directed to have a relook at the decision, specifically the process thereof, before any decision of allotment is taken. It has also been brought to the notice of the court that there have been subsequent developments whereby the state government have issued certain orders which have a bearing on the operation of such check stations. All these considerations shall also be taken into account when the respondents review the decision. As at the initial stage itself, this court had, by order dated 16/2/22, suspended the settlement of the check station and directed that if any checking need be done, the same be done so departmentally. The same shall continue till the matter is finally decided.
Yes.
Now, my lord, when we reconsider the matter, my lord, initially a thought came that if the writ petitioner can come up with a better land suitable for the purpose, my lord. Now, what transpires that she comes up with the same land which the other bidder, my lord, Rudolph Kindia, has offered. In that scenario, my lord, there is every possibility of a litigation, my lord. That is one aspect, my lord. Secondly, that land is not suitable because of increased traffic and VIP movement, my lord. Thirdly, there are government orders not to set up on the traffic where there are to cause traffic congestion on the national highway, my lord. So what district council did, my lord, because district council was running a departmental at that point of time pursuant to the orders passed by lordship, my lord, they decided to lease another plot of land on the bypass, my lord, literacy up. But it's a bigger plot of land, all the difficulties of traffic and this is a very suitable land, my lord. And ultimately, the district council took a decision that it will continue to run departmentally.
Now, what about her cancellation? She's entitled to some hearing.
My lord, in my humble submission, L1 bidder, I'll place some laws to that effect, my lord. The lowest or highest bidder, as the case may be, my lord.
There's no right. Fine, but then you entered into a transaction with her by saying that you ought to find suitable piece of land, and the same land which you had accepted before, bidder number 3, now you find unsuitable.
My lord, that was accepted.
Right, but the thing is that now, the only thing that comes to question is the entire decision making process. Arriving, fine, you can run departmentally. The end result, no quarrel. You have the power to run departmentally. You have a better and more suitable piece of land. Great, but the thing is that the entire your journey to reach there, whether that decision process is is it?
But the question remains, my lord, as a tendering authority, whether we have a right to cancel or
then where the order saying cancelling and dropping the entire thing.
Well, it's because of the pendency of matter we have not done that, my lord. But we can.
There was no pendency at that point of time. When the matter was disposed of, you called her, you settled the check station with her.
We have never settled the check station, my lord. We only wrote a letter to them to please arrange a suitable.
No, he said you have been selected. See, where's that letter? Resolve to allot the check station.
They have resolved, and now they are saying something else.
Executive committee is resolved to give the petitioner.
Well, I will annex that letter, my lord. The letter only says, my lord.
Would you suspend the functioning of this check station now? Until further orders. No, yes, Karigan doesn't. Yes, continue. Yes.
But my only submission is, my lord, in the change scenario, especially 3 factors came into the decision-making process, my lord. One was the subsequent government orders, and for that we have filed a writ petition, and we are operating only because of the stay order granted by this honorable court in the other proceedings, my lord. Otherwise, by now, all these check stations would have to be wound up, my lord. That is one aspect, my lord. Second aspect is that when we were operating departmentally from that Mukundur station, my lord, it transpired that it is causing a lot of traffic jam, and it is not feasible anymore because traffic is increasing day by day everywhere, my lord. So to say that what was suitable maybe at 1 year or 2 years back, my lord, may not be suitable today, my lord. And thirdly, my lord, third aspect was that every chance of litigation between the 2 parties because of the same plot of land, my lord. And fourthly, we have arranged a...
Where's the appear?
My lord.
And fifthly is what? To frustrate the arrangement that you made with the petitioner.
My lord,
that is the ultimate resolution of the executive committee.
My lord, well, I'll not comment on that, but my lord,
you cannot comment on that.
The submission that was made, my lord, that the administrative order must disclose all the reasons is not the correct law. I can place a decision on that, my lord. When a contract is cancelled or a decision to that effect is taken, that particular order, because all these aspects can be explained by way of an affidavit also.
But there's another decision that says that an order, now you can't supplement the reasons by an affidavit. It should be recorded there in the speaking order only.
My lord, that is not with regard to contract. My lord, this is with regard to contracts, my lord. I can just place this decision, my lord. I flagged as 2020, my lord, in this. Para 25.
Para 25. Which case is this?
CP Constructions.
Paragraph 25 at page.
Page 503.
Yes. Yes.
That brings us to the most contentious issue as to whether the learned single judge of the High Court was right in holding that the appellants were bad since they were without reasons. We must remember that we are dealing with a purely administrative decisions. These are in the realms of contract. While rejecting the tender, the person or authority inviting the tenders is not required to give reasons, even if it be a state within the meaning of Article 12 of the Constitution. These decisions are neither judicial nor quasi-judicial. If reasons are to be given at every stage, then the commercial activities of the state would come to a grinding halt. The state must be given sufficient leeway in this regard. Respondent number 1 and 2 were entitled to give reasons in the counter to the petition which they have done.
Not applicable, I think. This judgment.
But applicable in the sense, my lord, the broad principle, my lord, that in commercial matters, my lord, it is not necessary to give reason at every stage. The order itself may not give the reasons, and that can be explained by an affidavit.
But it's a different history. You see, it's not a question of a simple, a rejection or cancellation of contract. There, yes, we can understand. But in this case, it has a checkered history. Where it's going by your own actions only. Suppose you have not accepted as per orders of this court, you've gone ahead and said no, finished. We close this. Entire process. It's not feasible to have it here. Over. Not allotting to anybody. We done departmentally. Over. They have no grievance. It's not allotted to anybody else. But here, what you've done is that allotted, resolved to allot the petitioner, then changed in the same land, then shifting it to another surreptitiously.
But the sum total of all the whatever happened, my lord, is that the district council has practically abandoned the tender, my lord. They want to run it departmentally at Clay TFC, my lord. Looking at the various factors, my lord, of which 3 are very important factors, my lord.
No, these things should be done department. You can't actually outsource revenue collection to anybody else. Anyway, anything else?
But the other reasons are only to the effect that a successful bidder does not have vested right till
that won't apply here.
Till the tender is accepted.
That's in other cases where there is a clear bidding process, and okay, if I know highest bidder doesn't have the natural right to to expect the contract to settle with them. But this case is different because of the materials which are here in the case.
My lord, what these decisions basically say, my lord, that since the bid has not been accepted, my lord, no right accrues.
No, what about, see, you are resolved to give it to the petitioner, and you have said that make suitable arrangements. Now, was there any appraisal of suitable arrangements made by that the only reason there might be litigation? Can it be a reason?
But my lord, she comes back with the same land, my lord, which was offered by the other bidder, my lord.
So now suppose she gives another land, you'll give it to her.
My lord, as of now, my lord, district council is contented with running from the Clay TFC and running it departmentally, my lord. That is what appears to be in the best interest of everyone.
It's unimplementable contract, frustrated.
It will maximize revenue also, my lord, and it will keep at bay all the litigation also.
Difficult. He is right in one aspect. What relief will you get apart from just stirring up honestness?
Yes, my lord, if my learned friend has finished, your lordships, very small, 5 minutes, I won't take much.
3 minutes.
He is citing a decision, my lord, rejecting tender. Matter would have ended there, because lordship has given them the scope. Revise ended. I would not have come, lordship. It's not the question of rejecting tender. You have resolved to appoint me. Lordship, in his own affidavit, he is saying something else, my lord. Lordship will kindly come to his affidavit, paragraph 6. Page 4, paragraph 6, my lord, what he says. Well, I'll just read out. That with regard to the abandonment made in statement 11 of the writ petition, the deponent denies the same and states that pursuant to the order dated such and such passed by the Honorable Court, pursuant to the order passed by the Executive Committee convened a meeting on 18/10/22 and resolved that the petitioner may be appointed lessee as in provided the petitioner makes necessary arrangement for suitable land for the check. Lord, you can look into the records. Now, my lord, other thing is saying very strange. I picked up a land because that was available. Now he is anticipating there would be litigation. On what basis? a legal notice issued by a tenderer whose tender has been disqualified by this honorable court. This is absolute speculation, nothing else. And departmentally, district council during the pendency of the first case,
I think you have to sue for damages.
No, my lord. That's what, lordship, it's not a case for damage. If it is a wrong done after the allotment, your lordship, district council is still running it departmentally, your lordships. My lord, no prejudice will be caused. They have appointed me, your lordships. Need to, my lord, restore the appointment and direct them, my lord, to operate the check stations. Now the only question is come, my lord, within 5 kilometers. I don't know, your lordships. If your lordship is reluctant, my lord, to bring it back to...
My lord, that land
we cannot do that.
That land is totally different, my lord.
We cannot do that.
Allow me to operate from there, your lordship. Now what they are doing, my lord, what they are saying, running through agents, my lord, all the newspapers are reporting that this has been handed over to a private party without tender, without any following the procedure.
That is the normal.
Will your lordship will allow to continue, my lord, this kind of illegality?
Okay, hearing concluded, judgment reserved. Let me scratch my head and see what kind of orders can be generated.
Item 7.
Lordship will restore the, my lord, rule of law, your lordship. But what they are doing, this is nothing, a classic case of abuse of power. This should not go on, my lord. Oblige.
Same plot of land, my lord. My lord, the
same plot, what difference it makes?
Seed of litigation is already sown, my lord, the moment the other bidder sends a legal notice, my lord.
My lord, how?
It's imminent there will be litigation.
Litigation doesn't mean it will be successful or profitable.
That?
Yes.
Item 7.
Yes. Yes, Mr. Sahai. Oh.
Lordship.
Yes.
For the petitioners to...
Yes. Is that a GST matter, no?
This is not the GST matter.
Okay.
This is regarding the dues of the petitioners with the respondent corporation.
Okay.
I am a little handicapped. I just arrived last night. I have not had a chance to run through my learned friend's affidavit. I was praying if your lordships have it on some other day, any day convenient to your lordships.
Pay some cost to Mrs. Sahai.
The electricity corporation is adequately compensating him. At my cost, of course, where petitioners' dues from 1994 not paid till today.
What to do, Mrs. Sahai? You have a day after tomorrow. On the prayer Learned Council who submits that he has been able to prepare the matter adequately. Just the matter day after tomorrow.
Day after tomorrow. Grateful.
Enough 1 day time to read the affidavit, yes.
Main list item 21.
Yes.
My lord, this is second appeal from the judgment passed by the Judge District Council Court, my lord.
Yes.
So, appeal was admitted and question of law were framed, my lord, on 24/3/21, 24th March 21.
Yes.
So, the question of law is whether both the learned court below erred in law by not dismissing the suit being barred by limitation as prescribed under Section 3 of the Limitation Act 1963. Number 2, whether the trial court erred in law by not framing the issue on the point of limitation and record a finding thereon, although limitation was not set up as a defense. Whether both the learned courts below erred in law in taking the date of issue of latest notice as a date of cause of action, despite the alleged notice was not even proved as per law, and the fact the material on record. Accordingly, admit this appeal for hearing. That was the main issue framed, my lord, was on the point of limitation. The issue here is that the appellant had purchased the land as back as in the year 1968, my lord.
1968.
1968, and thereafter they took the position of the same and continued. Finally, in the year 1997, my lord, a Pilatus notice was issued to them to quit and vacate the land because it does not belong to them. When on the refusal of the appellant,
yes,
my lord, the appeal was, appellant had purchased a plot of land in the year 1968.
Okay.
Which they dispute and we say that the sale deed is not legal and proper. And that matter was examined by the court, by the trial court as well as by the first appellate court, and they came to a finding that this sale deed is not legal. So my first question is that a suit filed after almost 32 years of purchase of the land, my lord, can the trial court or the first appellate court consider that whether it is legal or illegal?
So you were the defendant. You were the defendant in the. This was filed by the respondent.
Respondent. I was defendant there, and then a judgment was in my against me. Then I filed an appeal before the first appellate court. First appellate court also upheld the judgment passed by the learned trial court, and therefore I am before your lordship by way of second appeal myself. So my first question is that whether the trial court may have taken into consideration or put well on the matter of the sale deed which was made in 1968. As per Article 65, my lord, of the Limitation Act, the maximum limitation for such type of thing is just 12 years, my lord. So how after 32 years, both the courts have tried the matter and determined the issue?
What are the reasons given? What are the reasons given in the trial court order decree?
My lord, no reason is given for limitation. Was not at all considered.
These are finding of facts. Whether this court sitting in second appeal would go into that aspect.
No, you want to go to facts.
Yes.
But if it's a mixed question of law and fact, why not? Yes.
Yes, my lord.
But then even limitation is a mixed question of law and facts.
Yes.
The fact is that they have not pleaded. No. There is no pleading in regards to limitation.
Section 3 says pleading is not necessary, my lord. Under Section 3 of the Limitation Act, even if it is not set up as a point before the court, an issue before the court, then also the court can come to the court, and it should be dismissed at the very threshold, my lord. This is the law under Section 3. So this is prima facie a case where it is hit by the law of limitation. After 22 years, the suit was entertained, challenging the validity of the sale deed, and came to a conclusion the sale deed is illegal.
Where was the final sale deed?
Sale deed, your lordship, only on the ground it was not admitted because the purchaser signature was not there. My signature was not there. Seller signature was there.
Not only that, the person who sold the property also didn't have the authority to sell.
No, but that was not challenged. Out of blue sea has come.
Both the trial court and the appellate court is that the person from whom the appellant had bought had no title to the property.
So Mr. Siddiqui, this second appeal is against concurrent findings.
Yes.
Tough call.
Yeah, concurrent finding about the validity of the sale, but my lord, I say that finding is beyond jurisdiction as it is hit by limitation. After 32 years, can it be done? Why the matter was not considered on the point of limitation as per Section 3 of the Limitation Act?
Here, I think.
I am not on the matter, on the merit of the case, my lord. First, on the point of limitation.
The bigger
if
issue
the court
here,
had
my
no
lord.
jurisdiction under Section 3, it should not have been. It should have been just dismissed at the very threshold.
The bigger issue, my lord, is that whether limitation was applicable at that point of time. My lordship is well aware.
Why?
It is only in 2017.
No, but there has to be reasonable explanation.
Yes.
When it doesn't mean that you can come and, if a cause of action has arisen maybe 50 years ago, then you come agitated now. The thing is that you have to think there has to be a sort of a nexus between the cause of action, the intervening period, and when you came to the court. That is the the logical. It cannot be that just what limitation act are applicable, you come after 50 years. So, but then there has to courts be satisfied that reasonable explanation is there for.
My cause of action, my title.
When did you come to learn about the sale deed? You are aware of?
No, it's only after they filed the written statement.
You are a sale deed.
Yes.
So your suit is based purely on a title dispute.
Yes.
declaration that you're the owners.
Yes, because by
eviction of
an order
Mr.
of
Pandit's client.
1997, my lord, what happened? There was a dispute in the family. So that dispute was finally decided in 1997. After which I issued a notice saying that please vacate. This land belongs to me. That was in 1997, and the suit was filed
in 2000.
In 2000. So that was 3 years. Even if 65 is taken into consideration, it is 12 years.
Position is at 1968.
No, but
what my friend is
68 sale deed was produced by you.
Yes.
In the course of the trial. The authenticity of the seal deed was it proven?
No.
It was rejected only on the ground that.
What came to final decision?
No.
It was rejected on the ground that firstly the respondent did not, the appellant here did not sign the sale deed. Secondly, the signature of the Sardar is also has also been is a forgery. The word used is forgery, because the present Sardar came and gave evidence before the court saying that this signature does not belong to that particular Sardar. And thirdly, that this person who sold the land had no authority to do so. Your Lordship will see the written statement and everything will be clear. We will come to page 21.
Let's put her understand first.
Yes.
The
We are bound by the pleadings here.
Of course.
There are 2 written statements filed by the appellant. In one written statement, she says that she had
Why
received 2?
Why
Amended.
2? Amended plain.
Firstly, she says that she has bought this land, and in the amended written statement, she says that she has leased out this land.
Who said that?
The appellant here. My lord, we'll just come to page 29.
Yes, 29.
29, my lord, paragraph 4, that the answering defendant is not a party to MCR case number so-and-so. It is not binding upon the defendant number 22. The statement in paragraph 4 of the plaint, insofar as the answering respondent is concerned, is false, fabricated and manufactured. The answering defendant did not receive such a pleader's notice. Even if received, it makes no difference, for the answering defendant had acquired the land at Sachkhle, Marbisu, years before. The order dated 5/2/97 or alleged compromise dated 28 June 1996. One by outright purchase, by sale deed dated 21st December 1968 and lease deed dated 5th April 1975, which was extended to 2050 by document dated 10/4/1982 in the back of the reverse side. So, Willard will see that firstly she's claiming that she has bought the property and then says it has been leased to her. The photocopies of the 2 documents are herewith enclosed as Annexure A, B1, B2 and are evident that the transactions took place 28 and 21 years ago, while the compromise took place on 28/6/1996. Now, my lord, will come to page 31. Page 32. This is the amended
statement.
Para 7. Now, realizing that she could not claim this land, now she changes her version. That being the manager of the private ancestral land of the Kharshiyang clan of Marbisu Sardarship, late Ukori Kharshiyang, can adopt any of his nieces as Rabiyang during his lifetime. Late Ukori Kharshiyang had adopted Catherine Kharshiyang, his niece. Late Ukori Kharshiyang and Catherine Kharshiyang had outrightly sold the sued land to the answering defendant at consideration of Rs 2,000 as per copy of the document dated 21/12/68 and confirmed by the then Sardar Marbisu Sardarship, late U Hai Singh Sun. So another issue was added after this amended statement regarding adoption. Now both the courts below also has said that there was no adoption.
No, positive finding is there.
Yes, positive finding.
Yes.
My friend, what my friend is trying to say is trying to claim this land is by way of adverse possession, indirectly, which has not been treated.
Possession of the land also.
Yes, because our suit is also for eviction. Our suit also is for eviction.
Yes.
In the trial court also only the appellant had adduced evidence and no independent witnesses were there. Whereas we had adduced as many as four.
Is that 968 sale deed anywhere here? In the records?
Yes.
No, it is not there.
No,
It's on the record?
No, here in the court record it's there.
Court record is there.
Just take it out.
And my lord, there were as many as 22 defendants. Only the defendant number 22 has.
What about occupying different plots of land?
Yes, but they did not. These are small plots.
Happening. So, Mr. Siddiqui,
and
the records haven't come.
Oh.
How is it possible?
I think records have not been called for.
Record may be called for.
Records have to be called.
Mr.
He recorded deposition only. Only deposition. Mr. Siddiqui recorded deposition, not the
entire record.
In the course of hearing it appears the records, inadvertently, the records have not been requisitioned from the courts below. Accordingly, call for the records. Just a matter after receipt of the records. See, Mr. Siddiqui, your whole case hinges on the 68 sale deed. Then,
yes.
Then
but my main point, my lord, is the limitation. Whether it could be taken after 32 years, my lord.
Whether that sale deed is a sale deed at all.
Yes. No,
and whether the cause of action for them arose after the said compromise and then they institute, you filed a suit, right? And then they institute the suit. So cause of action, we have to get cause of action whether the 68 will amount to the cause of action or whether
it's 97.
Yes. And if the cause of action can be attributed to whatever compromise 97 for agitating their.
But my lord, I was not a party in the year 1997 compromise or in that 145 proceeding of 2015, my lord. I was not a party there.
Anyway, we'll go through the findings, concurrent findings of the two court below. We very limited, what do you call it?
And the contradictory claims also, as I've shown.
We'll examine that. No, we'll examine against that. Whatever, we're not appreciating any evidence. Don't think that we're going to see whether any substantial points been made out. We'll answer those points. We frame 4 issues. I mean, like we will such questions of law. We'll frame it, and if there's no findings required, we'll say that there's no finding. This finding required to be given, or any decision, decision to be given on the substantial points. Yes.
22.
Should have pointed out to the court. I didn't know that because on that we just wasted half an hour. Yes.
It's a connected matter, right?
22.
23.
Yes, Mr.
My lord, this is the contempt, my lord, with regards to the non-payment of the nursing allowances, my lord. My lord, the judgment, they have also filed an appeal. They also there, and SLP was also dismissed by them. My lord, the page 15 of our petition, my lord.
Will it come to definition of who's nursing assistant again?
My lord, they are saying that.
So you saying you don't have certification, correct?
We have certificate, my lord. We have, my lord. They are saying that they have not specified under which act I am not, my lord, as a nursing
certification.
Yes, my lord. It is they have sent me for the course, my lord. It is not my privileges that I have went voluntarily and I have obtained that certificate, my lord. So in order to change that, my lord, the Ministry of Health has also given a concurrence while granting the nursing allowances to the petitioners, my lord. My lord, their affidavit, my lord, affidavit filed by the respondent on page 4, my lord.
When was it filed?
It is affidavit dated, my lord, 3rd May 23, my lord.
Yes.
My lord, from the beginning,
yes, excuse me.
Para 8 is continuing from page 3, my lord. That with regards to the statement and averments made in para 5 of the contempt petition, the deponent states that the matter was examined by the MHA, by order number such and such, wherein it was stated that to define a nursing person as per the Constitution of State and Central Nursing Act. My lord, which Nursing Act? Nursing Act of 1947, my lord. It does not define anything, my lord. Nursing Act. In response, my lord, I have filed the affidavit.
No, we state that to define a nursing person as per the Constitution of State and National Nursing Act, one should possess or hold registration stroke license so practice legally, for which he should obtain recognized qualification prescribed by the Indian Nursing Council, subsequently train and approved recognized institution, and so on, so State Nursing Council. Now the thing is that you're not registered in Nursing Council, correct?
My lord, nothing was that department.
Your certification is only that you're serving as nursing assistants. And training, they were sent for training also.
My lord.
And for all practical purposes, you are doing the same duty as the other nursing assistant.
My lord.
Okay.
My lord, in response in the affidavit, I have filed the, my lord, Annex 1, page 7, my lord.
You reply to it.
Reply to that affidavit.
Annex 1, page?
Page 7, my lord.
Yes.
That is 17 January 2017, my lord.
Yes.
I am directed to convey the sanction of the competent authority to grant nursing allowances and its arrear to the nursing assistant working in Assam Rifle as per the list A to C by Ministry of Health and Family Welfare orders mentioned here. My lord, if the Ministry of Health has also given that I am entitled for, had I not been Ministry of Health who is looking after the entire nursing areas, medical, they have given a concurrence, my lord. and the genuinity of the certificate at this belated stage, my lord, in the contempt proceeding. That was not a stand before the my lord in the writ court, neither in the appellate court.
So what does the writ court hold?
My lord, writ court hold, my lord, page 15 of the.
You just read what was the directions?
Direction was to since I was doing the nursing, I am entitled for the nursing allowances, my lord.
Okay.
My lord. And
without specifying the qualifications.
My lord, he has specified. My lord, page 15 of the writ petition, my lord, this contempt petition.
Okay. Absolutely. Page 15.
15, 1-5, my lord. This is the judgment of.
Yes.
My lord. My lord, can come to para 5 in page 15 only.
Para 5, yes, I have para 5.
Yes, my lord. So para 34, my lord.
Yes.
Even 33, on careful reading of the duties of the nursing assistant, it would appear clear that nursing assistant who are admittedly integral part of the nursing staff are basically entrusted with the duties of the nursing of the patient, and therefore the duties they discharge are very much like the duty discharged by the other nursing personnel.
Where does this come from?
33.
No. This order was where was order which in which context this has been quoted in this judgment?
This was my lord, para 33 of that writ judgment of the
writ appeal.
My lord, SH of 2011. My lord.
On account of reading the duties and appear that clear. I was interested in these in duties very much. They just say they like duty very much like. Anyway, but the various duties. So you are asking nursing allowance only, right? Yes.
My lord, even I have annexed the in my rejoinder, my lord, affidavit in reply, page 8 and my lord 9, page 9 of the page 9 of the affidavit in reply, my lord.
Page 9.
9.
Strange thing, you have not page numbered your affidavit. Annexure?
Annexure 2 series, my lord.
2 series is your qualification?
Yes, ma'am. My lord, in that.
Why didn't you present it affidavit? Anyway, yes. Okay, what do you want to show by these?
My lord, in that bottom line, my lord, down there, my lord, examination of by the technical trade testing provided, my lord, the authority, bottom.
This is the order dated 17 Jan. No. What are you reading? 2 series.
This is the 2 series, man.
Authority Arm Headquarters at so and so.
Yes, my lord. That is in the army, my lord. Whereas even the
but then on what ground have denied you? If why you come contempt, why earlier you were paid, right? You're getting nursing allowance.
Well,
you stopped. Now that the scheme stopped, now what is the contempt or what's it about?
Scheme is not changed, my lord. Scheme is not changed, my lord.
But you know been given.
They have not.
What is the position?
They have not been providing. They are changing the stand here, there. Now they are coming that no, your qualification is not recognized.
But the entire issue has been concluded by the Supreme Court, my lord, and pursuant to that, the lordships also passed an order. I have placed it, I have given to me. Well, what has happened, my lord? The Assam Rifle personnel, my lord, they are sent for the nursing training, my lord. That is course 4 months to 6 months, sometimes 1 year, my lord. Now, Ministry of Home Affairs held that only those who completed a proper BSc nursing, my lord, that is 4 years course, my lord, and who are registered with State Nursing Council or Central Nursing Council, only will be entitled to nursing allowance, my lord. That has been upheld by the Supreme Court in the Rajiv Khan's decision, my lord. This is from Guwahati High Court.
So have you been paid entire dues serving as nursing assistant or no?
No.
They were eligible at one point of time.
Till a certain period of time, my lord, your lordship passed one order in Joginder Singh, that is, your lordship will kindly see.
Yes.
May I just read this will clarify, my lord. Yes. The writ petitioner who is presently serving as rifleman nursing assistant is before this court with a prayer for release of the nursing allowance as admissible from the date of his remuneration from the post of rifleman general duties to the post of rifleman nursing assistant with effect from 16/1/22. Ms. Kharshona, a learning counsel for the writ petitioner, submits that the entitlement of the petitioner cannot be denied inasmuch as, though remuneration was effected on 23/1/2020, the same was with retrospective effect from 16/1/2002, when the scheme of payment of nursing allowance to the nursing assistants of Assam Rifle was still in operation, which, however, came to be discontinued from 1/9/2019. As per the directions of the Ministry of Home Affairs, the further submits the denial of his allowance to the petitioner, which is his just entitlement, is arbitrary and has caused financial loss. Mr. So-and-so, learned counsel for the respondent, submits that the nursing allowance to the nursing assistants of the force had been introduced with effect from 1/8/97. But however, as these nursing assistants were found to be not registered with the Indian Nursing Council or State Nursing Council, the said allowance to such nursing assistants was discontinued by the respondents from 1/9/2019. He, however, concedes to the fact that whatever retrospective entitlement, the petitioner shall be entitled to the same for the period when the said scheme was still in operation. The Learned Senior Counsel has drawn the attention of this court to the affidavit filed wherein these facts have been narrated. Para 3, which is relevant for the purpose of this case, for easy reference, is reproduced below. That the deponent states that the nursing assistant of Assam Rifle were not being paid any additional allowance till 30th/7/1997, and their pay and allowance were similar to general duty category. Payment of nursing allowance to nursing assistants of the force was introduced with effect from 1/8/97. However, payment of nursing allowance to nursing assistants of Assam Rifle was discontinued with effect from 1/9/19. As per the directions of the Ministry of Home Affairs, Government of India, White letter number so-and-so, 17/12/2012 and 19/1/2013, as they are not found registered with the Indian Nursing Council or State Nursing Council. Nursing assistants of the force have been advised to produce registration certificate issued by Indian Nursing Council or State Nursing Council for payment of nursing allowance. The petitioner has been registered as a rifleman nursing assistant retrospectively with effect from 16/1/2002 by order dated 13/1/2020. That is on the date when payment of nursing allowance was already discontinued. Hence, the petitioner has not been paid any nursing allowance for the period from 1/8/97 to 30th/6/19. He will be granted nursing allowance on producing registration certificate issued by the Indian Nursing Council or State Nursing Council. Having heard the learned counsel for the parties, the sought point for adjudication in the present case is only to the entitlement of the petitioner for the period from which he had been registered as rifleman nursing assistant till the date when the said allowance was discontinued. It is not disputed that the petitioner had been registered as rifleman retrospectively with effect from 16/1/2002 by order dated 23/1/2020, the date on which the payment of nursing allowance had already been discontinued. However, for the dates on which the petitioner had been retrospectively registered and when the payment of nursing allowance was allowed, it is undeniable that he is entitled to the same. In view of the facts and circumstances of the case, the respondents are directed to pay nursing allowance to the petitioner from the date of retrospective remuneration, i.e. 16/1/2002 till 30/6/2019 when the said allowance was discontinued. It is further directed that the respondents also pay interest on the entire amount, so and so, so and so. So, It is a fact, my lord, that from 30th June 2019 it has been discontinued.
No, but then
My lord, that is one aspect of the matter, my lord. The second aspect of the matter, my lord, the orders my friend is referring to, the learned single judge of this honorable court, my lord, allowed, because at that point of time it was not discontinued. Division bench upheld, my lord, and then we preferred an SLP against that, my lord. In SLP against the same thing, my lord, the question of law was kept open, my lord. May I just refer to that order, my lord. In my affidavit, my lord.
You have this order?
My lord.
Is that Joginder Singh?
I've given copy.
My lord.
So what do you have to say about it?
My lord, here also it is the department.
Because you're on the same footing, because you're not registered also.
My lord,
these people also, I think they were similarly situated.
My lord, if the department can send to the petitioner for the nursing courses, my lord, the department has not brought any correspondence that no, you should be registered, my lord, and in order to get the entitlement you should be registered. At no point of time, my lord, they have stated that. So can it be at this stage they can come and say that no, since you have not registered, how I will not give you.
What does Rajiv Khan say?
That is settled the matter, my lord. That these are in-house people sent on training, my lord.
Yes.
We will not be at par with.
You can't be at par with other nursing assistants who are registered with the Indian Nursing Council or the State Nursing Council. That's the only thing.
Moreover, my lord, the earlier order, how much it is enforceable, because the law was kept open, my lord, in the Supreme Court's order, my lord. In SLP. It's 6 of my counter.
Mr. Jha, what do you want to do?
My lord.
Contempt difficult.
As it is, my lord, it is a
with
very
view of the early orders of the court and Supreme Court orders there also, regarding that your differentiation. You take a call.
They can file a writ petition, my lord, for
They can file a petition.
Like the Joginder Singh.
Because if you want to maintain that case that them being sent for training, that there's no intelligible differential between you and the nursing assistants or registered with ENM and with the State Nursing Council, then that recourse is open to you.
My lord, that will.
My lord, the recourse to open to them, my lord, only in terms of Joginder Singh, my lord, for area, my lord, till 30th June, my lord, because there will be again covered by Rajiv Khan's judgment also, my lord.
It will be another fresh, my lord. That
naturally
we have traveled till my lord defended the matter.
All Afghan they're trying to press accelerator on one case only. So one order Supreme Court, you don't want to release them. And contempt also, no contempt. I don't think any contempt will be out here. In view of the orders of the Supreme Court and the other orders of this court itself. And most important, the scheme is discontinued also. Right?
30th 6, 2019. You have to challenge that, my lord, if you want to challenge. But they are again covered by Rajiv Khan, my lord.
Because they say that yes, you cannot equate them. You cannot equate your status with the status of those registered. That's what this Rajiv Khan says, right? So I'll just where's that paragraph? See para 6. See, you have this judgment, correct? Show him para 6 of the Rajiv Khan judgment. Take this here.
I've given a copy. I'll give one more.
Yeah,
This one.
Here's para 6. What is seeking? What is seeking is over. Please, para 6. You are aware of the judgment, Mr. Jha? No.
No.
Then we'll close the contempt in view of the judgment rendered by Honorable Supreme Court in the case of Union of India vs. Rajiv Khan, passed in civil appeal number 172. or 2023 on
16 January
16/1/2023. No, the contempt application has the contempt application is closed. Yes. I think we can quote this para 6 of the judgment is reproduced here and below. Will not elaborate this. Next.
25.
You can file for arrears.
You see, this case may be taken after a week.
Why?
In this case, what happened? The petition which I filed is very simple. Thus, for releasing the salary for the month of May 2021 till date.
No. What do you see? The last order.
Last order, substantially hard, I think.
No. Additional affidavit was filed by whom?
Additional affidavit filed by the government. The government has filed 3 affidavits as on today. 3 affidavits.
So what are your instructions on the fresh affidavit?
I will rely on my rejoinder just to show that I was appointed along with 2 other teachers.
Okay. On the Prohibitions, list after 1 week.
That's good.
You come prepared.
Yes.
26.
Contempt, no.
No.
Number 6 itu paragraph ni kata je. When was retribution filed? 22. 18 was the order of dismissal.
Yes.
Then, why you waited for 4 years?
My lord, the petitioner was from Bihar. He could not file it.
How will you condone 4 years delay? What have you said regarding your late approach?
My lord, we demanded the court of inquiries, and the petitioner respondents were not giving. Then ultimately we have to file a legal notice. Then they.
No. What is the order of dismissal? Let's see.
My lord, the order of dismissal is at page 38, my lord.
38.
47.
47 is a real notice.
What is the order, ma'am? Annexure 8, dated
Annexure?
5th November 2018. Annexure 8, page 47.
What do I have here? Annexure 8, page 47? No.
Yes, madam. Dated 5th November 2018.
In the fifth petition?
Yes, madam. copy is served, but file is different.
It is 38.
So my copy is 47.
Is that correct?
It's 38, my lord.
It's not correct. No, in my copy is page 47. My lord. Signature 8. Page 47.
You correct these pages, Mr. Jha. Mr. Petitioner to correct the pagination of the copy supplied to the DGI just after 1 week. At least the courtesy you have had with your opposite counsel.
27.
What's happening? Any petition been released?
Your Lordship, it's released only till October 2022.
Up to?
October 2022. Lordship, the District Council is supposed to come with instruction, Your Lordship.
Where is the council? Yes, yes. Any concrete proposal?
Well, I've sent the communication, my lord. They said they'll sit over, they will brood over it.
They sit for it, or they sit over it, or they will decide on it?
For 10 days time, my lord.
Lordship, in fact, they have been asking instruction from March this year, Lordship. 27/3/2023, if Your Lordship comes to...
Now they've got the check station, they'll generate your pension from there.
It has been with them, Your Lordship, for quite some time, but nothing is forthcoming.
Dr. N. Wazika, the other counsel for the JHDC, submits that the the concrete proposal is yet to be arrived at by the respondents. As such, is not in a position to place the same before this court today. Next, by the interest of justice, further 2 weeks' time is granted. It's expected next date that some proposal should be on board.
Positively, Lordship, because they have been asking from me much.
It's expected to be on board. Was it expected? I can't say positively.
29.
Oh, Lordship.
Yes.
Lordship, this is a matter regarding cancellation of Patta, Lordship.
Where's Mr. Day? He's coming. Matter regarding?
Cancellation of Patta, Lordship.
Patta?
Yes, Lordship.
You ready with the matter?
Lordship, ready.
Very good. Then we'll have it at 2 o'clock. Any other matter here? 2:15 is.
31.
2:15, you ready? 2:15 is.
31. 31.
31, respondent.
I'm ready, Lordship.
You ready? Then after 2:15.
Yes, Lordship.
Next one.
Yes.
What's the matter about?
It's for disability pension, Your Lordship.
You ready to matter or no?
I'll come next week, my lord. I'll come.
Yes, Your Lordship pleases.
Okay, next week is another prayer party.
33. 33.
Yeah, please, Your Lordship, this is a small matter, pension matter. So, if my
Immediately they are asking some time, my lord. But
only for his name is regularized, it is in the regular list also. But the only thing is that because of his anomaly regarding his date of birth, Your Lordship, they need some time for processing pensionary benefits and everything. Otherwise, he is entitled for everything.
Does he dispose it off?
Yes, Your Lordship.
By directing what?
Directing the respondent to clear his pensionary benefits. Yes, Your Lordship. Affidavit filing is with the respondent number 2, 1, 2 and 3.
What is this petition has been filed for?
Prayer part.
Release of the
paragraph 15, my lord.
Camp benefits of the petitioner who stated to have retired on
2017 2017.
2017.
No, date, the date. Retired on when he retired? In the year 2017. You don't have the date also.
This is 24/7/2017.
27?
24 July 2017, my lord.
17. From which department? From the office of?
From the office of the
District Medical Health
from the
Officer,
office of
West
the
Khasilas.
District Medical
Pinchai.
Health Officer, West Khasilas District, Shillong. West Khasilas District, Nongstoin, sorry. Next paragraph. The state respondents, by way of affidavit, has submitted that the delay has been caused due to the
Anomalies
anomaly
regarding his date
in the
of birth.
petitioner's date of birth.
It is at para 9 of the affidavit in opposition, Your Lordship.
As much as necessary approval would be necessary for coordination of his age of joining service. No, I'm sorry. Before that, sorry. He is stated to have been appointed when he was already overaged.
38 years.
That is about 38 years old. So, as necessary approval for coordination of his age joining service had to be sought, the pension, the process of the pension of the petitioner couldn't be processed. So, next paragraph. MSS Brachaji today submits that. What is this? What do you want to see just now? Submits that.
Submitted, Your Lordship. He was regularized by cabinet decision.
That the writ petitioner was not regularized initially, was not in regular employment, and has been regularized recently by the cabinet decision of the government of Meghalaya in March 2023.
22.
March 2022.
And he was placed as serial number 2.
And
He was placed as serial
no,
number
we don't
2.
record that, which also. And as such, in view of this development, the benefits as due will be processed accordingly.
Yes, Your Lordship.
How much time?
As per affidavit, Your Lordship, it is shown in all the 6 months time because approval is required for condemnation of his
only
age.
2 months over, my lord.
No, 2 months will do it, then will come to contempt. Next part, in view of the statements of the learned GA and the fact that the anomalies have to be resolved, the state respondents are directed to process the payment of pension and other terminal benefits to the petitioner expeditiously, preferably in a period of 4 months from the date of this order.
Small correction, my lord. It was the date of retirement is 31/10/2017, but the letter was issued on 24/7, my lord.
Doesn't matter, 31/10. Yes.
31/10.
Yes. But this repression of only stands source and dispose of. Yes.
Highly versed.
That may I please your lordship, before the hearing, counsel for the petitioner, they inform us that they will adjourn the matter today. But then,
Where's
that, sir, my senior counsel left somewhere for some urgent work.
You cannot make your submissions. Is it a fact that you only said you're going to take adjournment in this matter? Is that a fact?
Lordship? No, Lordship, it's not a fact, Lordship.
Then?
Sir, Mr. Sir K. Paul have informed my senior counsel, sir.
No, Lordship, I got instructions to go ahead with the matter.
This is very improper. You're all juniors and you can't conduct it this way. Where's Mr. Day?
So he left for some urgent work, sir.
Mr. Pasanti, you're appearing for whom?
Respondent number
3 and 4, Lordship.
This is not done.
Lordship, I'd like to bring in a fact before we start, Lordship. Lordship, the deceased and the Nokma, respondent number 3, has been deceased, and we've made multiple efforts to actually get the names furnished as to who has substituted Nokma, Lordship. But till date, we haven't been able to get the information, Lordship.
Is it correct that your senior had told them that you're taking time?
Lordship,
No.
Lordship, I have been instructed personally to go ahead with the matter.
Take down.
May I please, Your Lordship, please kindly take up this matter on Monday.
Listen to the order first. It is very unfortunate that when this court has, when the matter was called up, when the mother was called up, the counsels, because that time we said I'm calling him, he's here, and submitted that they were ready for the hearing. However, when the court sat again at 2 p.m. to take up the matter, what is your name?
M. Hajong. M. Hajong.
Ms. M. Hajong submits that her senior, the senior High Counsel is not available, as he was informed that the matter was to be adjourned. Stop. MS De Cruz on behalf of the petitioner, however, refutes this submission. And submits that no such intimation had been given to the respondent counsel. Stop. The hearing can be proceeded with. It only is noted that the counsels plus junior counsels should be well instructed with regard to mentioning or seeking adjournment of matters. This is matter of 2 weeks. If you cannot make the submission, you see your, how long you practice?
Well, it's not been a year. It's not been a year, Your Lordship.
Yes, you see. Now you should question your senior also. Now before lunch, you said that He's ready to argue, correct? And he said that Mr. Capon informed his senior. You find out from his seniors. Take copy of the order. Copy of the order be given to the respective counsel for the parties to bring it through notice of the seniors. Yes.